waiting for,
Good morning, everybody. Welcome to the Courtroom Files Live. It is Tuesday, the 28th of October. I am Michael Groff, filling in for Mr. Dan Soul, who is on a 2-week vacation, cross-country trip. And, of course, we wish him safe travels, and who knows, he may just pop on here during the show. You just never know. We'll start our day with Judge Simpson, which promises to be an interesting day.
No, it's okay. It's okay. I get that way when I'm around Darren too. So.
Good morning, Your Honor. Your Honor, the Office of the Washington County Prosecuting Attorney does not believe that there is a conflict between the Office of the Public Defender and this honorable court. However, if such a conflict were to arise and for the abundance of caution, we would waive any conflict.
Thank you. Mr. Brown.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Thank you. And the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided here. And to the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Before I call the first case, I just would note that I have a civil docket. I am covering a criminal docket. My staff may let you know. So I'm going to work through this the best I can. I just ask for your patience. And then why are you nodding? You patience is not you. Anyway,
married 24 years, Judge. Very patient. Happily married.
And she's a saint.
Yes, she is. Yes, she is.
What'd you do? You didn't know. You did something. You did something. That was almost a confession.
No.
I'm just saying.
I am. She is clean.
I'm so done. Ann Arbor commercial versus Scott Sundays.
Good morning, Your Honor. For the record, Tim Dabalski appearing on behalf of the plaintiff.
Your name, sir.
Scott Sunday, Your Honor.
You take the hands out of your pockets, please.
Your Honor,
where are we on?
Your Honor,
Yes.
I am pleased to notify the court that we do have a resolution. The resolution is as follows. The defendant will pay the plaintiff the sum of $2,250. That represents unpaid rent, court costs, service fees, statutory attorney fees. Is that correct, Scott?
Your Honor, yeah, that's correct.
That's correct. Okay, well, what's the rest of the agreement? He's going to pay that.
It's my understanding that he's going to pay that forthwith. Or
Okay.
we will give him 14.
And then what will happen?
I will file a dismissal with prejudice since he's no longer a tenant there. I don't want to have him have a judgment on his record, Your Honor. So if he pays that money within the next 10 days, I'll file a dismissal with prejudice.
Is that your understanding, sir?
Yes.
All right. And that was 2,250?
Yes.
And Judge, I would like to thank you for allowing me to appear over Zoom.
Not a problem, sir. All right, what I will do then, let's do it this way. If I need an adjourn date. All right, what I will do is I'll adjourn this to November 4th,
Okay.
2025 at 9 a.m. And you pay that, he files a dismissal, it'll come off the docket.
Okay.
All right, thank you, sir.
Thank you, Your Honor.
Thank you. Is everybody here on this? Yes, I know, but everybody. Cassidy versus, or Jerome versus Cassidy.
Good morning, Your Honor. Your Honor, Abby Cooper appearing on behalf of the Jeromes. Gail Rosen appearing on behalf of Paul Perez Cassidy.
Joe Lloyd, Your Honor, on behalf of Cassidy's.
Oh, boy. You know, it's like Lloyd just shows up in things. I know, everybody. It was a nice group before, and now Lloyd's here. All right. What are we doing on this? And we received, I did not grant it because I was off yesterday, but an ex parte motion to adjourn from Ms. Tope. So I've done nothing with that,
I've not seen an ex parte motion to adjourn from this topic.
probably because it's ex parte, but I'm just saying. But she filed, well, I don't even know if she filed it per se. She sent it to my staff. Indicated, I think, and correct me if I'm wrong, that she's on a plane, could not even Zoom in. So I don't know what that means. Wasn't going to deal with it yesterday when I heard.
She did send us an email to that effect, Your Honor.
Got it. Okay, that was the substance of the motion. All right, where are we now on this case?
Your Honor, we've spent I think a great deal of effort trying to settle this case on our own. We thus far have not been able to do so successfully. We've made some progress. Seem to be a few little hurdles in the way. I still think it's possible to settle prior to trial. If Your Honor is willing to take this on himself before a trial, it may be a judicious use of resources. But barring that kind of effort on the court's behalf, I think the only thing left to do is set a trial date.
Mr. Rosen?
Your Honor, we agree that we need to have a trial date. I mean, I think that'll give everybody something to shoot at. There's a couple of things we need to do beforehand. We need to clean up the pleadings a bit. I think there was some pleadings that were filed in early versions of this case that aren't in this one. And we'd like, for example, 2 weeks to get our pleadings cleaned up.
You mean in terms of the,
There was a counterclaim in one of the earlier cases. I don't know that there's even an answer in this case.
well, we had kind of postponed the filing of certain answers because the parties were working diligently to try to resolve them.
If we're going to try the case, we've got to file the answers and stuff. If we do.
Well, that's correct, but that is certainly not where we were hoping to head if we didn't have to.
I
So
understand that.
we were trying to, oh, I don't know what we were trying to do.
It's complicated. And the other thing that in conjunction with Ms. Tope, what I don't want to do, I looked at the release, it's not clear to me at all exactly even who the parties are. It looks to me clear that what she did is cut and pasted an old release. But we might want a hearing of some sort with the court just to resolve, who the actual landlord is, whether Ms. Tope has any claims or role to play in this. I believe she does not. But I'd feel much more comfortable with a court order. And so if she's got some claim she wants to argue, bring it now.
Well, that causes some, I won't say problems, but one of the issues is she certainly was holding herself out as the best way to put it is either manager or the landlord.
We believe she's a witness, and
Well, there's no doubt about that.
yeah, no, but if she can prove something, what I don't want to do is I don't want to finish this and then find out it's risen from the ashes. And so,
In terms of what?
her showing up and saying, no, she has a claim still. So what I would propose to do is we'll file a motion.
Well, and I don't mean to interrupt you, or maybe I do, but her claims, as I understood them, were really the landlord's claims. The landlord, however, may disagree with that.
And Your Honor, if I may refresh your memory, the Jeromes are here because the Jeromes filed a motion with the court indicating that Donna was the landlord, and the court declined that motion and indicated, no, the pleadings had been filed on behalf of the Jeromes. The Jeromes were on the landlord side of this action and denied the motion.
Correct. And that. Right, and in part, basically, I want to say this, there were things that were happening that I'm not sure were necessarily in the Jerome's best interest. I'll just leave it at that.
Yes.
And involved certainly Miss Hope, and then her claims. She had certain claims, and then the Jerome, I wanted to leave open the possibility, certainly for the Jeromes, that they may have claims in some way as to Miss Hope. I think I got that. So you're looking to straighten out.
One, to get our answer on record, so if we're trying a case, here's the pleadings, here's the claims.
Correct. I mean, if we're
And then-
I think a lot has to be cleaned up if we're gonna try it.
I think you're right, Your Honor. And the way that I think some of the discussion has been amongst counsel present in this courtroom is that we're looking to bring only landlord-tenant claims in front of this court for a landlord-tenant trial.
Correct.
There is a separate action in the circuit court that Ms. Topaz brought. It's an assault and battery thing that she's done.
Yes, I think she had done that.
And we have
She
a
had.
trial scheduled in that case in May, I think. But that's
May of next year.
next year. That
That's
case,
a perfect. No,
that case is proceeding and we will resolve it. But we don't want to duplicate stuff. And so I think if there's a landlord tenant case that involves her, I want to know it now and be done with it. And I don't think there is. But
If
I'd
it
love a
involves-
court order to that.
if it involves her,
Yes. I mean, something where she has a claim against my clients. I do not want that to resurface after we're done, other than what's in the circuit court. And I don't mean to be,
whether Ms. Tope has claims as against your landlord tenant claims.
yeah, yeah.
So the part, currently Ms. Tope is here through Cambridge Holdings LLC. She individually is not a part of these proceedings.
Correct. Does that help you? Or no? Given the look on your face, no.
No, I would like what I don't want to have happen is I don't want landlord tenant cases to surface in the circuit court and her say, well, those weren't addressed in the district court and I still have them. And I don't want her to refile in the district court. I want to be done with Donna. So, and I was hoping we could.
But that
Motion of some sort.
well, and that may be part of the other issue. As I understand, just on the surface, the assault and battery that she's claiming came as a result, allegedly, of involvement regarding the tenants.
Yes. I mean, is it a claim of her against the tenants? Yes.
Pardon? Right, her claims against the tenants. So I don't know. I mean, I probably have to think that through a little bit more, but I don't know that it can be fully separated out as you'd like it to. Because she's gonna make or can make certain claims. However, as to whether or not those claims are proper claims, I can't say for sure. I have my doubts, but
I'm hoping we can present you with a motion that will persuade you. So, But I'd like to be just done with that with Donna as regards to this case. And we can try this case fairly clean.
Okay.
And I don't want it to resurface. That's my goal.
Understood. Ms. Rosen, you have been conspicuously quiet. So,
Letting Mr. Lloyd do the talking today.
what?
Letting Mr. Lloyd do the talking today. So.
No, don't do that. For my sake, don't. Okay, so where do we want to go from here?
Let's start with a trial date and that we can work against. We'll file our pleadings within by the end of next week at the latest. To clean them up, we can circle stuff back and forth. With the permission of the court, we would file a motion and serve Ms. Tope and let her make her claim. I'd like to end up with an order, a final order as regards her in this court on landlord-tenant things. And we have to persuade. I understand.
But you understand that she doesn't. There would be an order maybe clarifying what she is in this case, but it doesn't make her go away.
Hold on.
I don't see that happen.
Okay. Well, we'll get as close as we can. And we still have to deal with the circuit court case, and I know that, and I'm not trying to get around that.
So in terms of cleaning up the pleadings, how much time did the parties need to get that done?
End of next week for us, please. That would be,
But then there's going to need to be potentially responses.
yeah.
So maybe why don't we look at, can everybody get everything done, even if the timelines are shortened by the 18th or 17th of November?
Yes.
Well, say the 18th.
Yes.
Is that a Saturday?
We're gonna need them. I can clean up my pleadings too, because I do
Okay.
think there's,
Oh, no, it's.
so why don't I go first?
On,
On cleaning up the pleadings, because I think on the landlord side, there's some cleanup to do as well.
okay. I mean, you know,
Because I don't want you to respond to what's on there currently. I think,
okay. Good. Okay.
What just happened?
I think that the landlord would like an opportunity to clean up the pleadings on the landlord side, so we should probably go first. And then the tenants are responding to the most recent pleadings.
All right, so how fast can you do that?
I can do that the week before the 18th, Your Honor.
The week before the 18th?
So that would
Then
be,
you need time to respond to that.
We,
So what's
and there will be a
next?
counterclaim,
Pardon?
and then we may have a counterclaim, you know,
That's what I thought.
yeah.
okay.
So, it's my next date after the 18th. Okay, so if the landlord has everything in order by the 17th, any responses, counterclaims and the like would then need to be addressed within the next 2 weeks after that,
Okay.
It's December 1st, something like that.
by December 1st. And then what I would do is I'll set another pre-trial final settlement conference December 2nd. Just because we have to make sure everything's in order. To have that. Go ahead, Mr. Mike.
If we file on December 1st and there's a counterclaim, we won't have an answer to that at that point.
Correct. Oh, I'm well aware of that.
Okay.
I mean, I
Yeah.
get it, but if I put it further out, then you're gonna have to answer. What I may end up doing is saying you have to answer the counterclaim by a certain date, a trial date.
Okay.
That kind of makes sense. I'm just trying to get everything back on track
Mhm.
so that we know exactly what we're dealing with, because we didn't Now, the one wild card in all of this is I'm not sure. I'm not sure what Ms. Hope will do with all of this. Because some of the claims, I think, from the landlord are going to potentially involve her, or maybe the counterclaims are going to. So I think it's probably better that we have that pretrial, because she's going to, I would imagine, have to respond to some of that. If that makes sense.
Yeah, I don't think we are planning a counterclaim that would be directly against either Donna or Cambridge. As a party. Now, she may be a.
Right, but the problem's gonna be that the counterclaim, so the initial claim is gonna involve certain things. Your counterclaim would then come,
Yes,
but then the response to that counterclaim, I can imagine, at least knowing what I know about the case, may involve some of the actions of this code.
okay.
That's-
We'll deal with it when it arises.
And you for
Yes.
filing the motion.
And how I've handled
That
this.
you want back.
Now, so how would you visualize this interacting with the motion we'd like, just to clarify Ms. Toph's status?
Okay, so what I'll do is I'll set a final settlement conference for December 2nd. Any motion you'd like to clarify the rights of the parties, I would need filed with an opportunity for the parties to respond. So you need to file that in time for them to
In time.
respond, and then I can rule on that
So you'd-
On that same day?
on that same.
You're arguing it on the second.
Yes.
Okay. So the second at 9 a.m. for final settlement conference and to argue any motions.
Yes. And then from there, once everything's cleaned up, then I can give you a clear trial date and see exactly.
Thank you.
I really want to say you're welcome, but
Have a direction. We know where we're
Yes.
headed. And I-
all right.
Thank you.
Thank you.
Thank you. Karen.
I-
All right. Good morning, everybody. Welcome to the Courtroom Files Live. It is a Tuesday. It's a live show. We've got all sorts of things going on, and I just want to show you something. Just if I may, maybe I don't know what's going on over here. I've got all sorts of stuff playing, and I got all sorts of stuff going on. Let's see if I can't get this. Well, whatever. Okay, so let me just explain what just happened. This was this just happened in studio during Judge Simpson there, and you never know what's going to happen on a live show. I'm going to take this camera and I'm actually going to show you this monitor over here just broke. I was trying to bring up the chat over on this other monitor and have it nice and large so I could read it over there. But what happened was these little supports here, one of them slipped, and that monitor just fell. And so that monitor, my friends, is done. And that is a brand new monitor here at Studio B. So, nevertheless, you want to help us out, support the channel. Those super chats and super stickers, those would really be appreciated. It's we're turning a Tuesday into a Monday, but it's fine. We are going to continue. Judge Simpson. Now, I will say this: we did have a very promising case here in Judge Simpson's court. Remember the guy, the Illuminati dude from the other day, that said that Judge Simpson's wife, all the way up to Elon Musk and President Trump, were responsible for why he was incarcerated or something. Well, he is due in court today. We'll see if he comes up. We'll hang with Judge Simpson for a little while longer. I will, maybe I'll start drinking early today. Anyway, back to Judge.
Universal resolution may be possible in this matter.
No objection from the people.
Correct, Your Honor.
Preliminary examination will be adjourned to November 18th, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case People versus DeMarco Henderson.
Jonathan Water, Assistant Prosecuting Attorney for the People. Alex. This is a waiver.
Your name, sir?
Marco Henderson.
It's just here. Mr. Warren Green.
Yeah, looks like. Yeah, you and he's there.
Lauren Brown, Deputy Chief Public Defender, appearing within on behalf of my client. Please state your name for the record.
DeMarco Henderson.
All right. This is a waiver.
Yes, it's my understanding that my client wishes to waive his right to hold a preliminary examination and agrees to be bound over to circuit court.
Sir, is that correct?
Yes.
All right.
I wanted the other guy that I spoke with him in the hall. Spoke with.
He's right there.
There he is. I didn't know if we all had.
Pardon?
So I didn't know if he had the same understanding as he did.
He has a greater.
Probably not.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Henderson. Mr. Henderson, can you state your name if you haven't already?
No, I already did.
You already did. We go way back now. Waiting for you.
Your Honor, we provided the court with a signed preliminary examination waiver. At this time, Mr. Henderson does wish to waive his right to a preliminary examination. We are continuing our negotiations with the people and we'll be squaring away the details as we approach his circuit court pretrial date.
Sir, is that correct? You're waiving the exam?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for the resolution.
Yes, sir.
People also waive their
Yes, Your Honor.
preliminary examination having been waived. Defendants bound over to circuit court on both counts. Mr. Warren Green.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
December 22nd at 1:30 with Judge Moody.
December 22nd, 2025, 1:30 before Judge Hamoud. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
There's there. Court does call the case, People versus Michael Siegel.
Jonathan Water, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. James Fifelski on behalf of Mr. Siegel, who's approaching. Can you state your name, please?
Michael Anthony Siegel.
Thank you.
Your Honor, my client will be waiving preliminary examination. It's my understanding the prosecuting attorney will not or will agree not to file an habitual notice in exchange for the waiver.
That is correct, Your Honor.
Sir, you're waiving your right to have a preliminary examination,
Yes, sir.
understanding that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Okay.
You understand that?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. 5,000.
Your Honor, waive formal reading of the complaint and or information and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
November 12th at 1:30 with Judge Conlon.
November 12th, 2025, 1:30 before Judge Conlon. Bond will continue. Thank
Be in
you.
touch, bro. 11:20.
Take care.
Have a good day, Judge.
Thank you. Don't know. All right. Well, why not? I can do civil and criminal all at once. Schizophrenic before. Oh, Gary. Costco called. I'll talk to you. All right. Clark Road Family Dividend Housing. versus, is it Deschanel Baker?
Good morning, Your Honor. We do have two witnesses. Would you like them to remain there or
Pardon?
where would you like my witnesses to come?
They can wait where they are.
Right there? Perfect.
What are we doing?
Okay. Your Honor, we've already,
I'm sorry, where am I supposed to go?
right here,
Right here.
we're a little crowded.
All right. State your name.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Deschanel Baker.
All right. What are we doing?
Yes, Ms. Baker has already provided possession, so today was just an issue of money damages that were requested.
All right. And you're unable to agree on that figure, is that?
No, sir. Correct. We do not have an agreement, Your
Do
Honor.
not have a figure.
Correct.
How far apart are the parties?
I haven't spoke with anyone from the property since I've turned my keys in, so I haven't been able to come up with an agreement from anyone.
Your Honor, if I
Go
may,
ahead.
the defendant has indicated that she has had habitability issues. It's my client's position that there was no habitability issues, and she is requesting damages in the amount of hotel bills that we did not receive, as well as, again, indicating a habitability issue. So we are very far off.
Your Honor,
Would you like us to speak in the hall momentarily, Your Honor?
I probably would, but hold on. What were you gonna say?
Your Honor, I'm not asking for any money in return. I'm just asking for the charges to be dismissed and for no eviction to be on my record.
Okay. I understand that last part. What is the total amount of plaintiff's claim?
Including court costs, it would be $3,055.63.
And ma'am, but the court's understanding you disagree with that because you weren't in the premises?
I disagree with that upon many factors. In the landlord's response to my current claim, it includes the statement that on August 6th, I denied entry to maintenance and they could see the fan because of the entryway. That is not true. I have proof that I actually asked management to meet to discuss my concerns, and the manager refused to meet me there. She chose to come to my apartment instead. This shows that I wasn't denying access to them. I was just asking to talk in a proper and safe environment to resolve the issues that I had, not only with just the leak and the mold and my pet dying in regards to everything going on in my apartment.
Majority of your claim, how much of that is rent?
$2,207.
I'm sorry, there was a sneeze. 2,000.
$2,207 for rent, $90 for the washer and dryer rent. Legal fees was $239.40. Additionally, there were unpaid utilities of $94.23.
Unpaid utilities.
Correcting consumers regarding that. And then, or I'm sorry, I think it's just GTE. And then the damages was the amount of $425. And that does reflect a cleaning fee. There was a secondary repair with the drywall due to tenant caused damage. And just a moment. And then there was a bulk fee where they had to remove bulk furniture from the unit after she moved out. And then there was also a replacement of the disposal system due to tenant caused damage.
Yes, upon me moving out, there was nothing wrong with the apartment. With me leaving, the disposal working.
Hold on, man. Were you in a hotel or not?
I was staying at family, friends, and relatives. I'm currently couch surfing. I don't have anywhere to stay.
Well, okay. I mean, during this period of time, were you in the unit?
During this period of time, I was not. I was staying at a family friend's house.
Had you notified the landlord of that?
Yes, I did.
In writing?
Yes. I submitted
Copy of the
them,
writing?
I submitted a paper in writing stating that I will not be paying
Okay.
rent, that I wasn't staying in the
I
property. because-
understand what you're telling me.
Mhm.
Do you have a copy of what you gave to the landlord?
Yes,
All right, have you shown the landlord that?
Yes, Your Honor. The defendant also refused entry for repairs during that time without her being present. And so our argument is that she failed to mitigate the damages. Additionally, repair was made that same evening to the leak in the ceiling that was caused by the HVAC system above her unit. So it had leaked through. She called in sometime after hours. By 10:30, 11 o'clock that evening, we have maintenance here on site to provide testimony that they provided immediate repairs, including fans. Within a week, they had a professional carpet company out there that provided additional remediation, including repair or cleaning the couch and the rug. And the repair itself was completed by the 19th,
Your Honor.
and this occurred on the 5th.
Your Honor, that's not true. On the date I was at work that they came to repair the apartment, maintenance
Well,
entered my home.
ma'am, let me ask you this. Did you let them into the unit
Yes,
to make the repairs?
yes. The date that she mentioned, I was not home. The maintenance guy called.
Are you disputing that they made the repairs?
No, I'm not disputing that they made the repairs. They did enter my home and make the repairs.
Okay.
On the 19th, after the leak happened on the 6th. They did not reach out and let me know when they were supposed to come. I had got no notification when the repair was supposed to be made. I had went up to the office multiple.
So, but why would that matter?
What's your question? Why would what matter?
You called in a leak. They came and fixed it. We're all in agreement on that.
They did not come. I called in the leak. No one communicated with me. I called in the leak the night that it happened. 2 employees came and he pulled out where the leak had came from because they said that they had not fixed or changed the filters out. The filters were supposed to be changed every 6 months. I had been living there for 9 months and nobody
Okay, that's
came.
fine, but that you called in a repair. What you're telling me is that they came out that night. Right?
They came out that night and put a blower in my house and just told me to leave it on the ceiling and on my furniture that had been ruined. Yes.
But
The leak was not fixed that exact night.
okay, but they don't necessarily have to fix it. They tended to what your complaint was, right?
Correct.
And then at some point within those next 2 weeks, they fixed it. You would agree, right?
No, it was not within 2 weeks.
I thought the 16, 19.
Your Honor, the drywall took additional time.
The drywall.
The drywall took additional time.
But the leak was fixed.
The leak was remedied. And then once the leak was confirmed, they did wait, I believe, a couple of weeks to confirm that the leak was finally
Was
fixed.
final.
And they had
did
a
the
third
drywall.
party, drywall company come out to provide repairs. At that time, once the repairs were complete, the tenant did, or the defendant did come back home. There was wet paint from the repair and she proceeded to poke a hole back through the ceiling. That is where the charge came from. The property did not charge her for the initial drywall. They charged for the secondary repair because she poked a hole in, alleging that it was moisture from the leak that had not been an issue for several weeks.
Did you do that?
Maintenance had previously told me that if a.
Okay, hold on. Now, you need to answer my question. Did you put a hole back in the drywall?
No, I did not intentionally put a hole back in the drywall. I allowed the water to flow into a bin instead of on my couch.
After they made the repair?
Yes.
What date was that?
19.
Your Honor, we have a photograph of the hole in the ceiling that indicates it's over the door. There's no couch underneath that photograph.
Your Honor, the hole where the leak had happened, my furniture was there. They had, in their counterclaim, said that I denied them entry and that I damage their property. I was just trying to get my problems resolved so that I could leave the property voluntarily. I was reaching out to compliance and upper management to
This
discuss.
grant is for what period?
It is for the period of July, August, and I believe part of September.
I moved out September 17th, right after our first hearing,
And the leak occurred when?
August 6th.
And why wasn't July paid?
July wasn't paid because I discovered black mold in the building.
Your Honor, we,
In the building?
Yes. Throughout the building was black mold.
Was there black mold in your unit?
No, sir. There were immensible other problems that I was facing while living there that contributed to me not paying rent.
Tell them you weren't paying rent?
Huh?
in August, we received, or my client received notification in August after the repair had been partially made and the drywall was pending, indicating she was not.
How long, when did you move in?
I moved in January 24th of
So
2021,
January,
but they,
hold on, January, February, March, April, May, June, you paid rent.
yes, on time every month
So the black mold came in when?
in July.
All of it?
Yes.
It just appeared.
The black mold, it came from an apartment that was also leaking water on the first floor. There was also an apartment leaking.
So
water
the
on
black,
second floor.
hold on, the black mold just started to exist in July?
The black mold did not just start to exist in July. It's when I became aware of the problems that not only I
So
was
when
facing,
you
but the other
didn't pay
tenants.
July, did you tell them this is why I'm not paying my July rent?
No, Your Honor.
Then you've got a problem. Even if true, which I have my doubts. So what I'm gonna suggest you do, and then, is why don't you take a moment to talk
Yes, Your Honor.
and see if you can resolve it? I will let you know, young man, I'm seeing certain problems with what you're telling me regarding any type of solution to this in terms of the monetary amount. But we can all have our positions. I suggest that you talk with counsel and see if you can work it out. If you can't, then I'll take you back and we're gonna work it out.
Okay.
Thank you, Your Honor.
But I don't know that you really want to talk to me today, but I'm always happy to talk to you. Thank you.
Thank you.
Thank you, Your Honor.
Judge Simpson makes even landlord-tenant cases seem pretty interesting. That's we don't normally cover a lot of those here. Our family was apartment managers back in the 80s, and you would get all sorts of excuses why tenants wouldn't pay their rent. So kind of an interesting case. Also, we hung with that for a little while as I assessed damage in the studio. All right. If you missed it earlier, if you're just tuning in, yeah, monitor over here fell over, and now we're sans one monitor, but we're carrying on with the show because ain't nothing stopping this train. Let me tell you that. Speaking of the train, it is rolling in Florida. We're gonna head over to Wade Mercer. He's got first appearances going, and let's see how fast he gets through all of these.
8:30 a.m. Corporal Brown, have you had a chance to play your first appearance video?
Good morning, Your Honor. Yes, we have.
Great, thank you.
What a fire alarm.
Ladies and gentlemen, at the jail, I'm Wade Mercer. I'm the county judge in Jackson County doing first appearances. From the courthouse, we have two attorneys involved in the first appearance process. We have Mr. John McDaniel, Assistant Public Defender. He's at the jail. I know that you can see and hear him. I want to make sure that you can see and hear our prosecutor also, so I'm going to ask if he introduce himself.
Jake Mitchell on behalf of the state.
Can you see and hear both of us, Corporal?
Yes, Your Honor.
All right, great. We have one person that has friends or family in the courtroom. That's Crystal Micheletti. Am I pronouncing that last name correctly, ma'am? Micheletti. Crystal Micheletti in the courtroom, ma'am. Because you have a couple of out-of-county warrants out of Leon County. Ma'am, according to what they've sent us, These warrants have bonds on them. They're showing a failure to appear on a petty theft with a $500 bond and another failure to appear on petty theft with a $250 bond. So it appears to me you've got a $750 bond total. I'm going to ask the jail to verify that after first appearance and let you know. But from what they've sent us, it appears to be a $750 bond. So what that means is if you post the bond, you'll be released and you'll get a court date later over there in Leon County. If you're not able to post the bond, then you'll be transported to Leon County and you'll go to another first appearance once you get there. Do you have any questions, ma'am?
Yes, sir.
In the courtroom, any questions, ma'am?
I do have one question.
Okay.
16, and now they're just getting her for that.
See if I got a date or anything on here.
I mean, she's been in jail, she went to drug court, she completed that, and they never picked her up.
Yeah, it does have a 2015 case number. That's all I know. I have no idea how long the warrant has been active.
I mean,
I don't know. No idea. Ma'am, but if she posts a bond, she'll be released, okay? All right. Wish you the best, ma'am.
thank you.
And just let her know, the warrant
Go
was
ahead,
issued
Mr.
in 2000 the warrant was issued in 2016, but the sheriff's office from Leon County never did enter into the system until just recently put the warrant into the system. So, but it was on CCIS since 2016.
Mr. Jackson, good morning. Mr. Jackson, you here? It looks like the best I can tell, Mr. Jackson, Corporal, help me out with this. He's already been first appeared on one count of failure to register as a sex offender, correct?
Yes, Your Honor.
Okay. So, Mr. Jackson, that statute has multiple reporting requirements. I will let you talk in just a minute. Let me tell you what I found out. So, for instance, leaving your job may be one violation, leaving your residence may be one violation, not reporting once a year or during your birth month may be a violation. Two different officers with the same law enforcement agency did two different complaints on you. I have no idea of knowing if they were aware each other was working on the case. But one is from April of 24 and one is from March of 24. In fact, they're 11 days apart. The complaints accuse you of two crimes 11 days apart. You've already been first appeared on one and you've got a $5,000 bond on that case, correct?
Yes, sir.
Okay. So, Mr. Mitchell, anything from the state?
No, Your Honor.
I don't know whether these two officers knew what each other was doing. Again, they're with the same agency. I'm not going to set you any additional bond. I don't think that's necessary. You've got a $5,000 bond for the same time period, even though it may be technically a separate crime. It's the same prosecutor in both cases. I'm not saying they've done anything inappropriate. I'm saying that I don't understand why there were two officers with the same agency doing two different reports 11 days apart for the same type of offense. So what I'm going to do is I'm going to give you an ROR on this case. It does not affect your bond in the other case. Your bond in the other case still is the same thing. Obviously, you've not been able to post it. It doesn't change. Just be aware when you get to court, you've got two charges instead of one. I'm sure that you're on the November 4th court date in the other case. So when you get there, you need to tell your attorney that you've got a second case that came in that you got first appeared on. Maybe they can go ahead and get you arraigned on that case also, because the court date in this case from today will be December 2nd. The other court date is November 4th. So make sure you tell your attorney there's a second count because your attorney may not be aware of it unless you make them aware. And I want you to go ahead and try to get everything arraigned on one day if at all possible. Mr. Jackson, do you have any questions?
No, sir.
All right, very quickly, I just want to take this opportunity to thank Bailey for the $10 super chat and $1.49 super sticker. Wahoo with the $5 super chat. Mama Joan, Grandma TCF with a $10 super chat. And Ashley, $10 super chat. We are well on our way to replacing Monitor 2 over here. That's awesome. We're trying our best to not turn a Tuesday into a Monday. We're here with Wade Mercer, TCF Live. Thank you so much. And now back to Judge.
Your Honor, I did note that the officer does mention that it was criminal mischief more than $200 in accordance with 806.13 subsection 2. That's in the body of the complaint. She does charge him with the first degree misdemeanor in the charging body of the statute right there for 806.131B2. We would contest that maybe it's just a typo error or something like that, that there is probable cause for criminal mischief because she mentions more than $200, but I think they do need to include the amount that it would cost to
replace the headlight and the tire.
Mr. McDaniel?
I don't disagree. I mean, I think that, it's hard for a police officer to say how much something's gonna cost. I believe they need to specify if they think it's over $200 though, and I think they've done that. And, clearly a headlight assembly is gonna cost close to that, and, that's not counting the tires, so, I don't have any objection to that.
I can't assume that. The officer's got to get some basis for a value that's clear in the case law. They've got to say, the victim estimates the damages to be such and such. I understand they're not going to have a real estimate that night, but it's a one sentence. The victim estimates the damage to be $300, $500, whatever. There's nothing in there showing a value at all. And when that happens under Florida case law, I can only find probable cause for the lowest degree criminal mischief, which is what I'm doing. So there's probable cause for second degree criminal mischief. I'm going to set your bond in that, but it appears you're already out on bond. And when I found out you were out on bond, I asked Mr. Goodson to see if the jail could give you your analysis, because a condition of the bond you were out on was a random urinalysis. So Corporal, do we have any urinalysis results yet?
No, Your Honor, unfortunately, he had used the bathroom before they brought him up here.
Okay. So Mr. Griffey, I'm going to revoke your bond in the case that you're out on bond in, which is case number 25479 CF. That's the one that you've already got pending, the drug offense you've got pending. So even though I'm setting your bond in the new case, which by the way, is going to be $10,000 cash or surety, you've got no bond in 25479 CF. Mr. Mitchell, if y'all give me an order revoking that bond, please, I'd appreciate it. So don't try to post bond in the new case, because you don't have a bond in the other case. You wouldn't get out anyway. In the new case, you do have a condition, no contact with alleged victim on the new case that does have a bond. Mr. Mitchell, as far as the court date, he's currently accused of a misdemeanor, but when the officer does a more thorough investigation, or they say attorney's office it mentions him jumping on the hood, and it mentions cutting the tires, and it also mentions, was one more piece of a headlight.
Mm-hmm.
So if they had put some number in there, I'd find probable cause. But my concern is, having just replaced paid for a car that got a deer hit it, as easily could be more than $1,000. So my question for you is, do you want him given a court date, or do you want to wait until y'all get the damage amount before y'all decide what court date you want him on?
I think we could go ahead and set him on the December 1st arraignment docket and
Misdemeanor arraignment.
yeah, misdemeanor
Okay.
arraignment. And I'll do my research. And if we get a cost that shows us more than $1,000, transfer it up.
So right now, we're going to put you on the December 1st arraignment docket, Mr. Griffey. That's good. That means you're going to be in misdemeanor court. And if you're still in jail, we'll see you on a different date. That's our out of custody date. So we may see you on our in custody date a different day. But right now, it's December 1st at 9 a.m. Mr. Griffey, you get a chance to use the phone, even though you've got no bond in one case. You still get a chance to use the phone to contact friends or family and tell them what's going on with your case. Mr. Griffey, do you have any questions, sir?
Yes, sir.
All right, sir. I wish you the best. Yeah, I don't know that the urinalysis, the urinalysis may matter, Corporal. It may matter to the state and the judge in the other case, because it may justify inpatient drug treatment. So still get us that urinalysis, please. Let the state defense and myself know the results. The next case is Danielle Sellers. Ms. Sellers, good morning, ma'am. Ms. Sellers, you're here for a sentencing or a potential sentencing. I believe that Mr. McDaniel has been working on your case. I know he has, because I've been getting emails, Ms. Sellers. So I'm going to ask him to give me an update. Mr. McDaniel, if you have the style of the case number, if you can put that on the record. I'm trying to pull mine up right now.
25517 MM.
Thank you. And Ms. Sellers, listen to Mr. McDaniel and where we stand in your case, ma'am.
Your Honor, I think the grandmother's going to be bringing some money up to the jail to be done for the psych evaluation. And we're just, I think Tammy emailed me earlier and said that, she's been out on a surgery this last week. She'll be back tomorrow, and she said that she could get it scheduled tomorrow. As far as the scheduling for that. And I know Stephanie was supposed to be there to make it. She just texted me. She was still at the dentist appointment. So I don't have any objection to the court wants to go and sentence her. Just keep open the possibilities of her going to the facility. And we can go from there.
Mr. McDaniel, you sent us an email, but I know that's not on the record. You or Ms. Colbert or someone found a possible placement at a program that is how long?
It's 90 days. It's, yes, it's a dual diagnosis facility, primarily for, people with mental health conditions.
So let me get the rest on the record then, so I can just also refresh my memory. There was a plea waiver and consent done on October 20th, about a week ago. And the charges, let's see if she played everything or not. I can't remember.
Resisted and breach of peace.
Resisting and breach of the peace.
Correct.
Yes.
You say it's supposed to be. Has it been dismissed or not?
While the case is still pending,
Not pending. She's pled. It's just the sentencing's the only thing left.
That's right. She has been sentenced.
Yeah, if she's already pled, we need to go ahead and get that dismissal done. Okay, so you've entered a plea of no contest to one charge of resisting an officer without violence and one count of breach of the peace. I accepted that plea. I set the sentencing for today because Mr. McDaniel asked that I consider some type of inpatient dual diagnosis facility. There's evidence that could lead someone to believe that there's both a mental health component as well as a possible drug abuse component. And those programs are hard to find, ma'am. So that's why I set the sentencing for today. So Mr. McDaniel, from you heard at a later date, if she can get in a program, is that correct?
Correct, Your Honor. She wants to go ahead and get sentenced. She wants to, get busy doing something, and the jail won't let her go into trustee until she's sentenced. And
Kevin, the jail sentence she just finished, how long was that, Mr. McDaniel?
60 days.
All right. Mr. Mitchell, first of all, what the state's position on imposing sentence today? Any objection to that?
No objection.
What is your recommended disposition?
Give me just a second.
Pierce.
What was the, just got out of jail? Has she been? Okay, so there wasn't an offer on that one.
I'm thinking it was trespass, but I'll go and look and see.
It was.
Loitering and prowling.
Yeah, it was loitering.
And it was from August of this year.
Doesn't look like there was an offer made on that one.
I'm probably going to sentence her to 9 months in jail, but I'm certainly listening to anything you have input, with the understanding that I'm certainly going to consider this program. If she gets in it or any other appropriate program, I'll consider it. But any input, Mr. Mitchell?
I was going to say probably 6 months or something, with no objection to her serving that sentence in inpatient drug treatment or any type of similar program that has been discussed.
Mr. McDaniel, anything else you want to add?
I was thinking also that'll give her, time to think about it, and also she'll get in this program.
So, Ms. Sellers, what I'm going to do is you've already entered a plea of guilty or no contest, ma'am. Based upon your criminal history and the fact that you just got out of jail, I'm going to sentence you to 9 months in Jackson County Jail with credit for the time that you've served, $370 court costs and fines. Ms. Sellers, I have no problem even with a 90-day program, because for drug treatment, we try to find 6-month programs. But for dual diagnosis facilities, it's a lot harder to find the program. So if we find a 90-day program, I don't necessarily have a problem with you going and doing that program, and that program fully satisfying the sentence. Now, if you can't get in the program and we can't find another program, Mr. McDaniel wants to bring you back up in a few weeks and ask that I consider changing that 9 months to 6 months. I'll consider that. But right now, I like the idea of you understanding how serious this is, and your sentence is 9 months in jail, unless we can find a program that you're willing to go to and complete, and then have some kind of follow through where we can kind of keep you out of the court system for a little while. So Ms. Sellers, your sentence is imposed. It's 9 months in jail with credit for the time that you've already done. Do we have that credit amount, Corporal or Mr. McDaniel?
11 days.
11 days credit, standard court costs and fines of $370 imposed in count one, court costs and fines waived in the other count. So second degree.
Mm-hmm.
So 60 days concurrent on the breach of the peace charge. So that sentence is only 60 days in jail, same amount of credit, no court costs and fines. So Ms. Sellers, hopefully I'm going to be seeing you in the next week, or the next, possibly even this week. But if everything works out and that program accepts you and you want to go to that program, Mr. Mitchell, Mr. McDaniel, and myself have all already said that we think that may be a good fit for you, so that we can get some more long-term. I don't know that get some more long-term help. I don't know that 9 months in jail, I'm afraid when you get out, we're gonna have the same problem again. So I'd rather get you some long-term help if that's what you need. Ms. Sellers, do you have any questions at all?
No, sir, Your Honor.
All right, ma'am. Hopefully we'll see you the next few days once you get the results of that evaluation, okay?
Yes, sir. Thank you.
Yes, ma'am. So, Mr. McDaniel, I'm not familiar with that particular program. So they require the mental health evaluation within a certain number of days of being admitted.
90 days.
And is that program, is that a free program? Is it to the defendant at least?
Yes, because I told Stephanie that no one could pay for anything, so I'm assuming that one is a free program. I know that you just have to pay for the evaluation and stuff to sit down to their doctors to look at before she comes in. Beyond that, I don't know much else about it because I haven't heard anything either, but Stephanie was supposed to be, she'll give us some more information, but she had that dentist appointment and she was going to let us know what it was about this morning.
Yeah, and if Ms. Colbert found the program, I feel confident that she's looked into it thoroughly. She's extremely thorough. Mr. McDaniel, that's everything I had this morning on my list. Anything else from the public defender's office?
Nothing else, Sean.
Corporal Brown, anything else from the jail?
No, Your Honor. I managed to get that UA on Mr. Griffey. I'll email it to you and John and Jake.
You've already done it?
Yes, sir.
If you managed it. You
No,
had
he
results?
got it. Yes, sir. He failed for marijuana. That was the only thing in his system.
Well, believe it or not, I'm surprised on that one. I thought with his original charge, I thought it was going to be methamphetamine, but good for
You
him.
and me both.
It's not great, but it's certainly better than methamphetamine. So
Yes, sir, it is.
yeah, they still need the email so that they can pass that on to the felony prosecutor. So the felony
Yes, sir.
prosecutor can take it into account whenever they get in the felony court. Thank you, Corporal. Mr. Mitchell,
Yes,
anything
sir.
else from the state attorney's office?
I will elaborate further on Griffey. I spoke to Captain Scarborough with Mariana Police Department. They're going to send an amended complaint to my office and to the clerk's office for that case.
I set a bond based upon what I thought the damages might be, but I can't find probable cause. That's my understanding of the law. Mr. McDaniel, Mr. Mitchell, if I'm wrong about that and they don't have to allege an amount, let me know that. My understanding
you're
is
right.
on petty theft and criminal mischief, if they don't allege the amount of damage, I have to assume the lowest amount there. So we have it on petty theft sometime where they steal something and the officer never says how much it's worth. I have to assume it's the lowest amount.
Yeah.
No, you're absolutely correct. I'm not disagreeing with what you're saying. You're absolutely correct. I guess my point was that I know you were going to set a high bond and it wasn't going to make no difference anyway. And that I was trying to tell Jake to no need to keep talking about it. So, but yeah,
How did you know I was going to set a high bond, Mr. McDaniel?
I just knew you
Come
were.
on, come on, tell us.
I mean, if it was a jaywalking case, it was still going to be 10,000 on the bond. I realize that, so that's why I wouldn't make a big deal of it.
We worked together how long now?
It's been counting before also, it's been close to 20 years.
Yes, I think you probably know what I'm probably going to do probably as well as I do. So I appreciate it, fellas. Anything else, Mr. Goodson? All right, ladies and gentlemen, that concludes first appearances this morning. It's 8:49, first appearance court.
All right. Well, Wade Mercer wrapped things up very, very quickly. And so that was what's going on over there. Now, we did have this case over here in Judge Simpson's court earlier, if you missed it. Landlord tenant, I know, but it was kind of contentious. And we do have a conclusion to, they went back to see if they can come to an agreement. Let's see what happened there. I think we know how this is going to turn out. Shocked. Oh. Did we lose audio? I think we did. All right. We lost audio. Well, there you go. That's why we have the monitor on here, folks. It's been that kind of a day. Here, let's go back. Let's go back here. I know that's a little bit of a spoiler alert, but it looks like they weren't able to come to an agreement. But let's go ahead. Oh, wait a minute. Let's go ahead and try and get this. And I think I do believe Dan is here. Hold on a minute. Let's bring up Dan.
Mikey,
Daniel,
can you hear? How you doing?
I do hear you. You might unfortunately hear me. We just had that audio bug in the StreamYard, but I'll try to compensate for it here.
I can hear you fine. If they can hear me, we're good.
Okay. Yep, I hear you.
Cool. All right. Well, we were attempting to broadcast to you earlier. We're in Amarillo. Oh, some serious rigs going by. We're in Amarillo right now, and we stopped by the Cadillac Ranch, and was hoping to kind of hoping to do a live right out by the actual cars. Here, let me take the phone. We're at a distance. I don't know how well you might be able to see, but there's cars way out there. They're Cadillacs that are half buried in the ground, and the idea is to go up. The idea is to go up and graffiti them. But there is like an Arctic wind going through here today, and we were absolutely freezing our butts off, so we had to call it.
It's like 40 miles an hour.
Yeah, I'd rather be in Michigan right now with the wind off the lake than
we did talk about that. We talked about that on our weather video this morning. Some very cold air plunging into Texas this morning, and it seems like that is, you've got the ground truth going on there.
Yeah, no, it's brisk, but I took some great pictures, and we'll show them on the pre-show, not tomorrow, but Thursday, and that'll be good.
Awesome.
But it's a cool place. I don't know if anybody's ever been here, but if you're traveling the I-40, you got to stop at a Home Depot, grab yourself a couple of cans of spray paint, and go out to the Cadillac Ranch. You'll see in the pictures when we show them on the pre-show, these cars are so caked with paint over the years that there's like a 6-inch thickness to it in some spots. And it's just a real cool thing. It's right on the side of the highway, and anybody can drive up and just have at it.
That's awesome.
It's a real cool spot. So really wanted to show it to you live, but you had court and we were turning into icicles. So now you get me from the car instead.
Yes. It's already been a very eventful live show around here. So we're having all sorts of fun stuff. We've been checking in with Judge Simpson. We're waiting for the Illuminati guy. We have not seen him yet.
Oh yeah, that is today.
It was supposed to be, and it was supposed to be one of the first cases up. But instead, we got landlord-tenant, although it turned out to be a little bit more interesting of a landlord-tenant case where, it went kind of sideways there. Gotcha. Bottom line, someone doesn't pay their rent and comes up with excuses why. Classic.
Yeah, all right. All right, Michael. Well, I'll leave you to it. Thanks.
Yes.
Thanks for having me on. Have a good rest of the show. And next time we go live, we'll try to make it a little more interesting. But yeah,
still interesting.
All right. Well,
yes.
We'll share some pictures on the pre-show.
Awesome.
So if you're
Thank
not
you.
a member, become a member so you can see pictures of the Cadillac Ranch.
Yes, it's just $2.99 a month. That's like 1/3 the cost of a Starbucks nowadays.
Yeah, $2.99, which makes it 1/300th the cost of a Starbucks. Because I think a Starbucks is like $299 now.
Yeah, it has gotten a little bit pricey. We know we have the girls, so yeah, they love their
Sure
Starbucks.
Klarna there now.
Yeah, they ask for a term, like a 5-year term loan agreement.
Yep, easy payments.
Yes.
All right, my friend. Have a good show.
You too. Have a good drive.
All right. Bye.
That is Dan, ladies and gentlemen. He is a fearless leader, and so he is off and doing what he does. He is on his way to attend the day of his daughter's wedding. So that will be exciting. He's gonna He'll be, he's doing the drive because Dan does not like to fly. Why not? I don't know. You'll have to ask him. That's a great topic to bring up to him on the pre-show. And I suggest you do that tomorrow. All right. Let us pray. Let us go to giving you our promise, our devotion to 9 to 11% more Judge Boyd. Here is Judge Boyd. Oh, there we go.
2-4, State versus Reginald Tyrone Green. Can I have parties approach and announce for the record?
Lauren Espinoza for the state.
Good morning, Your Honor. Bernard Hampton and Andres Campbell for Mr. Green.
All right, and are you Mr. Green?
Yes, ma'am.
All right, you're here on a motion to reconsider sentence?
That's correct, Your Honor. The court
Yeah.
may recall a few weeks ago, he was here on a revocation proceeding. He pled true. There was an agreement with the state for a recommended sentence on his revocation of 6 months in the state jail facility. Obviously, that's not binding on the court, and the court's view was here and provided testimony about his mental health issues and some of the circumstances regarding the underlying offense. It's an unauthorized use of a motor vehicle, which involved his parents' car. In talking to the parents, it's not something they were excited about pursuing, but we didn't represent him on the underlying charge, so here we are. The situation arose that after the father's testimony, I think the court was inclined to reconsider if there was some documentation that would have supported or maybe corroborate the mental health circumstances that he had been encountering in his life. And also, I think there was submission at the time from probation that he had not accomplished anything while he was on probation. What we have tendered to the court for purposes of reconsideration are medical records we were able to obtain from the University Health System. You may recall his parents had him involuntarily committed at one point. These records we've obtained kind of, I think, demonstrate to the court some of what Mr. Green has been dealing with. On page 2 of the records, I think of the medical records, page 1 is just the cover sheet they sent us, but page 2 has an assessment per EMR of bipolar 1 manic with psychotic features. The other pages we have selected for the court's review kind of corroborate that, go into a little more detail about his bipolar. And really what happened, I think, in history was his circumstances domestically were kind of on the downside. His wife left him. She took the kids. He went into a pretty deep state of depression and precipitated all this stuff. He ended up losing his job, living on the street, picking up shoplifting cases, and here we are. But to his credit, he didn't just completely go off the deep end. He got involved in a church, a ministry here. We have included as an attachment to today's motion, a letter from the pastor of that ministry, a Blaze ministry here in San Antonio. And she corroborates that he had been very, very active in that church once he joined it. He, not just in the ministry program on a volunteer basis, but he also helped a lot just in the physical plant, the maintenance, just the heavy lifting and toting that is associated with maintaining a property. And so I think his heart has been in the right place. His mind has been anywhere but where it should be. And under the circumstances, his father and mother would love for him at some point when this is behind him to relocate to where they're at in Texarkana. They will provide a home for him, get him back on his feet. He's got a job prospect there that is very promising. And his biggest concern right now is being able to resume some type of productive life, be able to pay child support to his children, and kind of renew and reconstruct his life with his children. And with those things in mind, we're hoping that the court would reconsider the agreed recommendation from the state. It obviously, the court's judgment is what we abide by, and we live with that, and we're grateful for your reconsideration of this matter. But the recommendation from the state wasn't haphazardly arrived at. I think we discussed his whole situation, the underlying offense, the circumstances of his living at the time, mental issues. And so we felt like it was appropriate. And we're hoping the court would reconsider the 14-month sentence that was assessed.
State?
Your Honor, based on what is said, I will echo defense counsel's sentiment that these items were discussed with me prior to us bringing that agreement to the court. However, I would just defer to the court's decision on this
All right.
matter.
Well, what I can tell parties is that once the court enters a legal sentence, the motion for reconsideration, that's really not a legal motion. His only options, and I'm not your attorney, I'm not trying to tell your attorneys what to do. His only option is a shock probation, because the court legally cannot reconsider a legal sentence. So the motion to reconsider will be denied.
All right, okay. Even though we're within the 30-day period, Your Honor, for plenary jurisdiction?
No.
For what it's worth, Your Honor, if I may, it was at the court's recommendation that, and the court did announce that there's not a legal means or method or vehicle to do this, but that the court would consider the new information in that format, and which is why we had filed it at the request of the.
We can go off the record. My suggestion is a motion for shock probation.
Got it, understood.
Okay. Thank you very much. Thanks, Judge.
All right.
Thank you.
And now with regards to shock probation, depending on how long he's been in jail, the court will consider that.
Thank you, Your Honor.
All right, you're welcome.
We'll pick up the conversation.
All right, good morning, everybody. Welcome to the Courtroom Files Live. It's Tuesday. I'm Michael Groff, filling in for Dan Soul, who you just saw a few minutes ago on the road up toward Michigan for his daughter's wedding. Beautiful thing, and a great time to be had by all there. We're having a great time here. It's a Tuesday, and Judge Boyd is waiting for the next contestant to come on down. Maybe we'll try to go back to that Judge Simpson audio before everything kind of went kablooey, and we'll see what we can do. Looks like there you go. Well, Judge Boyd, why do you do this to us? All right, well then we'll take you back to the epic conclusion of that landlord-tenant situation in Judge Simpson's court. We'll try this again, see what happens. Oh. I think it broke again. Yep. All right. Well, what we're going to do is, hold on. Let's do this. We're going to get this audio to play, darn it.
All right. Are we on that?
We weren't able to come up with an agreement. I would like to request that this case proceed to trial. I've been dealing with ongoing issues regarding Huron Vista, including attempts to charge me additional amounts that I don't believe are fair. I also want to note that when I moved in, I was not given a properly signed lease. There were more inconsistencies with rent charges, my move-in date, and prorated rent.
Did you pay the rent?
Huh?
Then I don't know what you mean by properly signed lease.
When I moved in, I did not have a signed lease. I did not sign a lease.
Okay, but you stayed there, right?
Correct.
You paid rent.
Under the impression I had a signed lease.
That's the only reason you paid rent?
No, Your Honor.
The moment you stayed there and paid rent, the tenancy was created. So I'm not sure why you are bringing up the fact you're saying there wasn't a properly signed lease?
Because I would like to move forward and take this to trial. I don't believe I'm getting my points across.
You don't believe what?
I'm getting all of my points across.
Oh, no, I'm understanding that. But they, quite frankly, I'll be honest with you, I mean, I'll hear the case, that evidence to put on, but I'm not clear what you're really arguing.
What I'm arguing is that I did find the paper that I reached out and submitted in writing about the black mold when I found it in July. I did reach out to the apartment complex. I would like a court-appointed attorney. I don't feel.
That doesn't happen in a civil case, ma'am.
Okay.
If you're gonna go to trial, you're gonna have to try it yourself. And my question is, are you prepared to do that? Because you're gonna be bound by all the same rules, the court rules, evidentiary rules that counsel would be bound by.
Yes, Your Honor, I understand.
You're prepared to do that?
Yes, Your Honor.
I don't understand what your defense is to this.
My defense is that since I've lived in this apartment complex, I have not gotten any communication in regards to my problems that I faced living there. I've reached out and talked to more than 5 property managers that's worked there in the past 9 months. All of my problems were not fixed. They were completing work orders that were not actually completed. They were just marking them as complete.
Ma'am, what did they not do?
Anything.
No, that's not an answer.
They did not fix the leak. They did not. I'm sorry.
What do you mean they didn't fix the leak?
Give me 1 second. Landlords are legally required to keep the.
I don't need to be read anything. You have told me that they did not fix the leak. I just went through the whole thing. You agreed they fixed the leak. So what do you mean they didn't fix the leak?
What I mean by they didn't fix the leak, they did not communicate with me as a tenant to give me the communication of when they were going to enter my apartment and how everything was going to get handled. No one communicated back to me in any of the responses when I've reached out to them and let them know the problems that I were facing living there.
Did they fix the leak?
Yes.
So what do you think them, if it's true, which I'm having some doubts, that they didn't talk to you at all? What are you claiming that's worth?
I'm claiming that that's worth the $17.90 that they initially brought me to court for.
Because they didn't talk to you?
They didn't communicate and they entered my apartment without permission. They violated my rights. Not only one.
You call, say I have a leak. They at some point, because that's an emergency situation, enter your property. And that's your claim?
They entered my property the same night to fix the leak. And then they tried to enter my property 2 weeks prior to the leak happening to enter my property to fix it with no communication. They came to clean my couch a week after the problem had already happened and my couch was ruined. That's a $2,000 couch that was ruined. The leak was not only in just one part of my apartment, it spread throughout the whole entire apartment. There were cracks in the ceilings that were supposed to be repaired from construction that never showed up.
Entering your unit inconvenient.
It inconvenienced me because I was not only dealing with just
you know
the
what?
leak.
You've got your witnesses here today.
I do, Your
I'm going to squeeze you in because this is going
I also have
this
a
is going to
witness.
be a quick trial.
I also have a witness here
That's fine. I'll hear from everybody and then I'm more than happy gonna render that. The only issue is that I have criminal cases, those have to take precedence.
Absolutely.
But I'm ready to hear this today. It's not gonna take time at all. I'm gonna tell you right now. Cause I do not, I'm gonna let you know, young lady. I will hear anybody's claim. I do not understand your claims. And the claims don't make much sense to me.
And I will make sure that I will make them make.
They don't make sense to me. Young lady, I'm trying to communicate something to you. I've been doing landlord tenant for over 35 years. Your claims don't make sense. But if you want to go ahead and call witnesses, do all the questioning, go through all of that, we'll do it.
Okay,
And then I'll render my decision and you're stuck with it.
thank you, Your Honor.
Wow. That should be very interesting. I don't know if we'll be here for that. This is one of the times there where landlord tenant is, well, it's pretty interesting. It's more like excuse court, I think is what we'll euphemistically call that. All right, we haven't checked in with Judge Dad this morning. Let's see what's going on up in, well, still in Michigan. I believe Judge Dad's over there in Wayne County, so we will see what he is up to.
5T721182. All right. Mr. Zayed, your appearance?
The victim's here also.
Okay, perfect. Can I have Mr. Zayed, your appearance, start your video. Ms. Bynum, start your video. And I need the victim, Ms. Moore, to start her video. Good morning, Mr. Zayed, your appearance.
Good morning, Your Honor. Justin Zaid, P81051 on behalf of Ms. Bynum, who is present, consents to appear via Zoom. Ms. Bynum, can you say your full name?
Hyla Bynum.
Ms. Moore, I need you to start your video, ma'am. You're not driving. Please tell me you're not driving. Unmute and tell me your name.
Peter Moore.
Okay, you're not driving, right?
No, I am. I'm pulling over right now.
Why are you driving when your case?
Huh?
Just pull over, please. I got all these people waiting for me and you. I really am
Okay,
not.
I pulled over, sir.
All right, Ms. Bynum, you can get off the phone anytime. I don't know who you're talking to. Are you talking to somebody, ma'am?
Who, me?
No, the person behind.
I'm not talking.
I don't understand. You got the phone up to your ear? Aren't you on Zoom?
Yeah.
Mr. Zayed, I have a stip that says Keita Moore does not wish to proceed. I don't know what he wants me to do on these.
Your Honor, I think that it says voir dire for intention. I think that it indicates, just putting on the record, that it is in fact Ms. Moore's intention not to proceed with this matter. And at that time, I would motion the court for dismissal. I'm happy to just do that now if that's more appropriate.
All right. I just got to ask you a question. Am I missing? How long you been practicing? Can I ask you?
Almost a decade, 10 years.
So I've been a lawyer for 42 next month. I've been here for over 30. For 41 and a half years, the prosecutor's office would move to dismiss it. I'm going to say to you is this. I don't know why he wants me to dismiss this on my motion once you move to what, once I'm convinced that the victim does not wish to proceed? Am I missing something?
I think, Judge, every prosecutor's office does it a bit differently. I know that Oakland County will simply defer to the court saying they can't proceed, and then I would move to dismiss. So that's kind of consistent with how they do it in that court.
You know why? It's all political nonsense, right?
Certainly, they don't want to be the one
I don't
dismissing the
like
case.
politics. I don't like politics.
They don't want to be the one to dismiss the case. I understand.
I
that.
don't like politics. I hate politics.
I I'm with you on that.
I had to run in 1994, and I just don't understand anymore what's happening.
I understand.
To set this for a jury trial and to impanel the jury, and then they're barred from prosecution for all time because jeopardy attaches. That's what I have a good mind to start doing. Set them all for jury, impanel the jury, and then jeopardy attaches. That's what I have a good mind to do. Did he talk to the victim?
He did.
Did you talk to the prosecutor, Ms. Moore?
Yes, I did.
Do you wish to proceed on this case, or do you wish to have the court dismiss the case?
I wanted to proceed, but I just made the decision after talking to the prosecutor just to drop the charges. I just feel like she haven't learned her lesson.
Wait a minute,
And
look at me. You're looking at the roof of the car. I need to
I'm
talk
sorry.
to you. I need you to look at me. You said you wanted to proceed, but what?
I don't know. I don't know. I don't know. She just haven't learned her lesson. I just had to have surgery.
Wait. Just talk to me. To proceed with the prosecution. Is that true or false?
I mean, that I guess it's true. It's true due to the fact, the discussion that we had.
I don't want you to guess. This is too important to guess. You know what I'm saying? I want you to tell me, yes, Judge, I don't want to proceed, or yes, Judge, I do want to proceed. It's up
Okay,
to you.
Okay, I don't want to proceed.
You want me to dismiss the case?
Yes, please.
You don't have any intention of going forward on this case?
No.
You move to dismiss, Mr. Zayed?
Yes, Your Honor, respectfully.
Dismissed, motion of defense.
Thank you very much, Your Honor.
Prosecution. Witness does not wish to go forward. All right, case dismissed. We're going to cancel the bond conditions. Do you have any questions for me, Ms. Bynum?
No, sir.
So case is dismissed, motion of the defense. Thank you very much.
Thank you, Your Honor. Have a good day.
Good day. Good luck to both of you.
Thank you.
Thank you.
Lexi Jane Elaine Don, T525B724898. Who's here for, okay, counsel, your appearance?
Did we call Ms. Don's case? I'm sorry.
Yes.
Okay, I'm sorry.
That's all right.
I didn't late. James Girametta on behalf of Lexi Don, Your Honor.
Ms. Don, your name, ma'am?
Lexi Don.
So you're going to try to do what, counsel? Get her into sobriety court or what?
I think that's the plan, Your Honor. I want to talk to Ms. Don about it a little bit, so we'd ask for adjournment so we could get a deviation letter, and I can make sure Ms. Don understands what that involves.
All right, so here's what I'll do. I'm going to set this out, but I want you to understand, I'll give you 2 weeks on the PCC, so that should make it November the 11th. And then the exam.
Judge, that's a holiday. Excuse me, that's a holiday.
Do I have a state day that week?
We were trying to do the 14th, but we haven't received a response from Mr. Mohammed yet.
Call him, Mr.
I think he mentioned that, Your Honor, when I was in a breakout room with him. So knock on wood. I think that'll work for him.
Plus,
Good morning, Mr. Mohammed, your appearance. We tried to reach out, I guess, and see if you could do, the 11th is a holiday, 2 weeks from today.
Yes, on a Friday.
Oh, so you're gonna do the 14th for us?
I don't know if it's going to be me, but someone from my office should be covering that day, yes.
Definitely, so I can schedule things up for the
Yeah.
14th at 8:30? Okay, good enough. All right, so ma'am, I want you to understand, your lawyer's asking for an adjournment. You have the right to a probable cause conference within 14 days of the date of the arraignment. If I grant his request, that means that the probable cause conference will not take place within 14 days. Do you understand that?
I do, Your Honor.
You waive that right.
I do.
Anybody force you to do that?
Nobody.
All right, I'll accept the waiver. We're going to set it for November the 14th at 8:30 will be the PCC. Preliminary exam will be November the 18th. At what time, Lisa? 10, 10:30?
10:30.
At 10:30. No, no more adjournments, so council, okay?
Understood. Thank you, Judge.
Good enough. We'll see you guys here then. Have a good day. Anything else? Detective Tulas, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstone Police Department.
Anything you need to add or bring up on this case?
No, I hope Miss Dawn gets accepted to the sobriety court program. I think it would benefit her.
Ms. Don, let me see your AA verification. Put it up to the camera.
Did
Put
you?
it
I
up to
didn't
the-
hear what you said.
I need to see your AA verification. Put it up to
Oh.
the camera.
Yep, I have that right now. Let
Have
me.
you
just go
seen it,
grab
Mr. Garametta?
I haven't, Your Honor, no.
I do have it. I have it right here. I have a meeting I'm going to at 9:30. I found a good spot to go to.
You've been at least 6 times so far?
I have. Yes, I have, Your Honor.
Let me see
get
it,
that-
please.
Here, one moment. Let me figure out how to turn the camera around.
Are you on a
Okay.
scram tether?
I am.
Okay. Okay, good enough. We'll see everybody here on November the 14th at 8:30. Thank you.
Thank you.
Thank you, Your Honor.
Thanks. Joshua Michael Skeens.
Oh.
This is file number 24M715739.
Good morning, Judge, staff, John Graziani, P number 433.
Can I have a probation?
We have Joshua Skeens. Judge, as you can tell, the letter has been submitted.
Let me ask Mr. Skeens his name first.
Go ahead. It's Joshua Michael Skeen.
All right. I need a probation order, please. All right, we do have this letter from the Monroe County Treatment Court, Circuit Court. Treatment, the court is probation department's recommended jail. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Judge, I did very little on that. We were just simply submitting. We were just concerned about the submission of the letter. We felt that he could continue on with the program. We're just asking for mercy again because of the fact that he's been working, he has complied with that, with the exception of what happened in this jurisdiction, Judge.
Can you do me a favor and call in Beth? Give me 1 second, please.
Again, he showed up over here.
The car he was driving with us.
I was the owner of the vehicle.
And so I want you to understand something. I'm going to be you understand it, right? I need to wait for the probation officer.
You want us to just take?
No, you're fine. Just, she should be in momentarily. I just want to. Get a hold of her, John.
I had you hold hand, but what's the action of the phone? And then this.
Is Ms. Wilds here today?
She is, but I was the one that contacted the Monroe, so I can work for you.
So she sent you in?
Yes. I attached the letter that they.
I know. I want to make sure I'm doing this right. I need, if I wanted you, I would have called you. I need her.
Okay. Right, for related.
Correct. To ever come in.
Yep.
Ms. Wilds, your name? I
I
haven't done this in a while. I'm gonna make sure I'm doing it right. So he's gonna be in the treatment court there in Monroe. As I recall it, all I'm doing is assessing fines and costs, and I'm gonna order him to successfully complete that program and provide proof.
Yes, Your Honor. Are you?
I'm gonna keep him,
transferring this?
nope,
No.
I'm gonna keep it here. But
So you gotta take your hat off.
I'm gonna keep it here, and I'm just gonna order him to comply with all terms and conditions of their treatment court, fine him. And I don't think I'm gonna order anything else, but 93 days if he doesn't comply.
Yes, Your Honor. And that's perfect. If we're not transferring, that's
This
exactly.
fines, cost, probation fees, true?
Yes, sure.
All right, you're all set. Thank you. 24 months. Did I let everybody finish over here?
Judge, I'm set except the state because of the fact that he's currently got that Monroe County scenario with the sobriety court. I'm asking that there be nominal fines and court costs. Because this gentleman's making one of about $15-16 an hour. I make $15-17.
All right, anything else?
There's nothing else, Judge.
Is there anything else?
On my behalf, I would just like to say, this did occur here in jurisdiction, and I apologize for.
Listen, this is your last chance. If you weren't in their drug court, you'd be going for 93 days, right? So you've used every available break that one's entitled to in this world. I mean, I'm not that. I'm gonna trust that you're being really compliant and that your heart's in it, because I gotta tell you, if you don't turn your life around at this point, I don't think it's coming.
And that's understandable.
24 months probation, you cannot leave the state without the consent of the court to violate any law or ordinance. If you change your address or place of employment or home telephone number, you must notify probation. You have to report as directed. Your motor vehicle, I don't know if they ordered this, but I have to order that it be immobilized within 7 days. We have to order a mobilization within 7 days for a period of, I'll give you the minimum for 90 days, okay?
Judge, vehicle, excuse me, has been sold.
Then I'm gonna need proof of that. You're gonna have to go to the Secretary of State, and you're gonna have to provide me with proof that that vehicle's titled in somebody else who's not a relative's name. Do you understand that?
Yes.
My order is that you comply with all terms and conditions of probation in the Monroe County Treatment Court. I'll go light on your fines, 100 fines, 300 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are 5 1/4, screening fees 60 for 585, probation fees are 480 for a total of 1,065. If you violate, your probation could be revoked. You could be incarcerated for 93 days. So again, I'm running these terms concurrent with Monroe Treatment Court. So if you violate there, you violate here. Do you understand that?
Yes, sir.
I'm telling you, you got to change your life around, son, or this record is horrific. I will let you pay this at the rate of $50 a month. I will start this beginning November the 10th and the 10th of every month thereafter. If you don't have the money at any point, you come in here and talk to me or call the court. We'll go on Zoom on or before the due dates. Be glad to give you an extension. I don't care how many times we have to do it. You'll meet with the patient. You're all set.
Judge,
I really wish you well. You got to embrace that program. I'm telling you, your record is, you're going to end up in prison, not jail.
yes, sir.
Good luck. Thank you.
Thank you, Judge.
People against Nate and Sarah.
All right. Good morning. Welcome to the Courtroom Files Live. It's a Monday. Thank you so much for joining. Tuesday. It feels like a Monday. It's a Tuesday that's turned into a Monday here. We'll talk about that later. Another place where it's a little bit of a Monday. Let me show you. I'm going to just take you. Dan does this every once in a while. Shows you something a little bit interesting that's going on out there in the wild. If I can do this, let's see if I can. Well, all right, let me see if I can bring up. Here we go. Here I am. Let me just pop myself off the screen. Let me bring this up to full screen here. This, you maybe have, we're seeing it, me setting this up behind me here on camera. That is Hurricane Melissa. It is now beginning to cross the island of Jamaica. And that, my friends, has winds of 185 miles per hour. It is the most powerful hurricane ever to hit the island of Jamaica. Why am I even bringing this up? Well, because, of course, just a little cross promotion here, I suppose. I do weather content, the Phoenix, Arizona weather discussion. And I know this isn't necessarily relevant to Phoenix or Arizona. But what it is relevant to is history. This is a historical weather event. It is the most powerful hurricane we have ever seen strike Jamaica. It is unbelievable, a frightening storm. And so I just thought I'd show you. What you're looking at there is quite literally graphic violence, as that eye is crossing the western portion of Jamaica. And of course, the worst of it is on the east side of the island. So I thought I would just kind of bring that to everyone's attention. All right. That having been said, I suppose we can get back to it here. Sorry about that. We're just having a little technical glitch to bring that to you. Let's go back to... We can go back to Judge McNally, if I remember how to do this. Oh, don't worry, guys. I've only been doing broadcasting stuff for, what, 30, almost 30 years, 27 years, 27, 28 years, whatever. Anyway, let's get back to Judge.
Of course, a recommendation.
Okay. Is that what you want to do, sir?
Yes.
And you stipulate I can use the police report to establish a factual basis?
Yes, sir.
Can you mark that? Sir, if you plead no contest, Tabitha, I need you to mark this, please. If you plead no contest under 7694A, I'm sorry. If you plead no contest under 7694A, it has the same effect as a guilty plea. Here are the possible penalties: up to 500 fines, 93 days jail, costs are all those. You understand me?
Yes.
I'll defer the proceeding. I'll order a pre-sentence or screening and assessment. You'll come back. I'll set terms and conditions of probation. If you're compliant at the end of the period that I set, the case would be dismissed. You understand me?
Yes.
You agree to that?
Yes, sir.
All right. And did you sign, read, and understand an advice of rights form here today?
I'm sorry.
Did you sign, read, and understand your advice and rights?
Yes, I did.
Okay. If you plead no contest, you will be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
Okay. Any questions before I go on?
No,
To
sir.
the charge domestic violence, how do you wish to plead?
No contest.
All right, I'm going to review the report. I had it marked as Peoples 1, Is there any indication in here anywhere that there was alcohol or drugs involved?
No,
Has anybody forced you to plead no contest?
No, sir.
Good enough. I'm gonna go ahead and accept the plea. I'll defer it under 794A. I'm gonna order a pre-sentence report. We'll give you a sentence date. So you're gonna go over down the hall when I give you a new sentencing date, then you're gonna go over to probation, you'll be interviewed, and then you'll come back for sentencing. What do you have for me, Lisa? Are we gonna go to the 3 weeks out?
Yeah, November 18th at 8:30.
I have a conflict that day,
Okay,
being in another jurisdiction. Is it possible to have the 14th?
can we do the 14th? Any reason we can't do the 14th?
No, we can do that.
Let's do the
8:30.
14th at 8:30. You gonna be able to get out of bed, Ms. Belcher?
And on time.
I know you are. That's why I asked the question. That's why I asked you the question. All right, give me 1 second. Why is this, I just need to check one thing here. Yeah, Judge Hester had already signed the warrant back on September 26th. So you understand everything, sir?
Yes, sir.
Do you have any questions?
No, sir.
Anything else?
Not for the defense.
All right, have a good day. Thank you very much. Thank you. Do we have Mr. Nelson out there yet? People against Ronnie J. Goshen. 25D12595. Come on up here, sir. How you doing?
Pretty good.
What's your name?
Ron Motion.
You been to court a lot?
With me?
Have you been to court much? Good. All right, so this is a handicap parking and you have the sticker. You just have to make sure that's on your mirror, okay? Nice and visible, all right? Okay, so they're dismissing, case dismissed. Congratulations. I wish you well.
Yeah.
Good luck.
All right, ladies and gentlemen, as promised, before Dan went on vacation and I took over, one stipulation that I had to follow. I am contractually obligated to do this, and of course, I want to as well. In Judge Simpson's court, we have the SovSit guy. Who is the SovSit guy? Well, if you remember from last week, this is the guy. Again, we teased this earlier in the show. This is the guy that blamed pretty much everybody and everything for his incarceration or everything that happened to him, from Judge Simpson's wife all the way up to Elon Musk and Donald Trump. And so now we will be presenting him to you here in just a moment. I see that he is in Judge Simpson's court. So we're going to head over there and I want to make sure that we bring this to you.
I want to make sure that at this point, it would essentially just be a warning we're requesting from the court to defend it, to make sure there's no contact with the victim. We also want to make sure that he understands that applies to other third parties.
All right.
And Your Honor, my client and I have discussed that today. He is aware, of course, of the no contact order. We've discussed. Sorry, got distracted by Officer Allen. Judge, we have just.
Get the feeling.
Yeah, it happens. We've discussed the no contact order. He understands that he cannot have contact not only with the complainant, but third parties, intending that contact to get back to or involve the complainant. So we have discussed that. It's my understanding he is aware of that. Is that correct, Mr. Teague?
Yes, ma'am. All right, so sir, you understand all of those terms in terms of the no contact?
No contact is no contact.
That's it. No contact. That means even through third parties. I will give you this ammunition. I'm sure she wouldn't care. You don't want that issue if it arises coming before me. I will tell you that Judge Slade does not tolerate that at all. So I'd suggest that you follow the advice of your counsel and make sure none of that occurs. Understood?
Yes, sir.
All right. Bond will continue.
Thank you very much, Judge. Have a good rest of your day.
It'll never end. You hear? Okay, let's do it.
Here we go.
Where's Mr. Brown? Okay. Yeah, Ms. Constantine, you may want to move out of the way there.
Oh, sorry.
So, no, you can stay there if you want. You have the paperwork? Oh, you're bringing it. Okay. What's my day? 28. Court does call the case, people versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly fine.
felony. That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right,
Mr.
count two on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right, so that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. Refrain from saying anything because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from the mobile gas station
now
on
knowing
Maynard.
what the
South
charges
Main.
are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I
And
understand
would
that.
not be shown any favoritism.
Yes, and I would like to subpoena my discovery packet, please.
If at some point in time you wish then to be represented by counsel, you need to make that request to the court.
Okay, I've
to
tried
do
calling the
that.
public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, yep, and I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Secures GTL recordings from when I was in the MDOC at ARF level 4. And WCC pictures and.
Sir, I have listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly
your
fine,
own-
Mr.
sir?
Simpson.
Sir, for your own
I'm not on Social
protection and
Security.
preservation of your rights.
I'm not on social security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not
I
go
have
to the forensic center.
I have to, in terms of these proceedings, make sure that you are competent and.
Oh, I'm very
no
competent,
link.
Cedric Simpson. You can tell. I'm very
Thank you, sir.
intelligent. I have a GED. I got a GED in 2013 in 3 months.
All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to subpoena my GED from the Adult Transitions Program in 2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way, if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29th.
AM. I will sign an order to.
Can you give me a PR bond, please, Judge?
I'm sorry.
Can I please? I would like to request a PR bond.
This time you can file a motion, or somebody can file a motion before the court, and I'll consider a written motion. But at this time, I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman phone
Check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right. So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right. It'll come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try it.
Before we go off the record.
Y'all corrupt as hell. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery and as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and he didn't need the discovery either, that he knew what was going on and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered, either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases and supply it directly to him.
Understood.
All right. Thank you.
All right. Well, I hope you were taking notes on that case. I certainly was. Let me see. Let's see if we can follow along with what's going on with that case. Let me see here if I can bring up my notes. All right. Let's see. So it is the fault of Trump, Elon Musk, Judge Simpson's wife. He's representing himself. No AI bot hacked. An AI bot hacked the camera at the gas station where the crime allegedly took place. He's had a GED got a GED in 5 months or 3 months. He's very smart and very competent. He doesn't need a competency evaluation from WCC. I suppose that's a community college. And he's not mentally ill, nor is he on Social Security. So there you go. That's it sounds good to me. Let's see. Let's go ahead and get you 9 to 11% more, Judge Boyd. Goodness gracious. Do we not have audio? We don't. Okay. Let's try this again. And now we will go and get the audio. Every time I try to switch stuff, audio breaks. There we go.
Jorge Morales, can I have parties announced?
Lauren Espinosa for the state, Melissa Christian for the defendant.
And are you Jorge Morales?
Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
I have, yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Morales, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor. Counsel. Yes, sorry.
Ms. Morales, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance penalty group 1 grams to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? You're gonna need to speak up so the
Oh, yes, ma'am.
counsel, has your client been able to provide you with any defenses?
He has it.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I did.
Mr. Morales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a entry, did you understand?
Yes, ma'am.
Court will find, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine. The state is recommending community supervision. They're taking into consideration 2024 PF 20631. Did you understand that to be the plea?
Yes, ma'am.
Yes, Judge. Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, the DOEP and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offers states exhibit 1 in all attachment.
We have no objection.
State you may be excused.
Thank you, Judge.
All right, off the record, yes? Let me see. Oh, you're in number 2. You just have to go there. Oh, let me see.
Okay, now it is.
All right, thank you. We're back on the record. Mr. Morales, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
While Judge Boyd reviews that, understand once again, you can join us tonight, 8 p.m. East, 5 p.m. Pacific for Sidebar. We'll be, even though Dan is out, we'll be down in person and
States exhibits 1 and
join us then.
attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we just like you followed plea bargaining with state's recommendation of probation.
All right. So, sir, Mr. Morales, who is Victor Hugo Lamont Sanchez to you?
My ex-brother-in-law.
Okay. Do you have any children?
Yes, teenagers.
All right. Do they live with you?
Yes. My oldest is 22.
And what do you do for a living?
I was in construction, but I got hurt and I haven't been. They've been paying the bills right now, so but I need to go back to work.
All right. So is that workers' compensation or something else that's happening? Unemployment?
Nothing. I didn't file for nothing. I don't want to.
Okay.
I don't like taking nothing from.
Well, so, just as a side note, people see that as taking, but if you're hurt on your job,
Yeah.
somebody's supposed to pay for that. Too many times people have this idea, oh, I'm hurt on the job, then I'm just going to let it slide. When if you let that slide, who knows, maybe there's something wrong with safety standards there. And if you just let it slide, then the lack of safety standards will continue.
But it's a lot of paperwork. It's a lot of they ask this, that, this,
All right, this is what the court will do. The court is going to sentence you to 5 years in the prison, suspended and probated for 6 years. If you're drug tested today, what will happen?
I'll probably come out dirty.
All right, how often are you using?
Maybe like every 2 weeks or so. But
And what are you using?
cocaine and alcohol.
All right. There's going to be regular reporting by Zoom or in person, regular random UAs. I want a referral to felony drug court, a TAP evaluation out of custody. If he's not accepted into felony drug court, then follow the recommendations of TAP. Take in consideration 2024 PF 20631. There's a $1,000 fine that will be probated. Proof of employment within 45 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. No contact with Victor Hugo Lamont Sanchez. Field visits 1 time per month for 6 months. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. And there's going to be 30 sober meetings in 30 days. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful?
What's the parenting classes?
Oh, that's where you learn how to parent, right? And sometimes people will say, well, I know how to parent.
But I have no kids. It doesn't matter. They're small. They're not
Yeah,
small.
you said they were
Yeah,
teenagers.
there's 22 and 20.
So let me just
24,
tell you,
26.
usually when people have children in this court, I do parenting classes.
Yes,
You know
ma'am.
why I do that?
Yes, ma'am.
Because sometimes people don't understand that your drug addiction,
Yes.
you're picking up these charges impact the children.
Yes, ma'am.
They just think, well, I didn't use it in front of them, so it's all fine.
Yes, ma'am.
But all of our actions as an adult impacts our children.
Yes, ma'am.
And so parenting classes are going to teach you that. I always tell people, maintain your sobriety for yourself, but if you're at that stage where you can't do it for yourself, then maybe having that parenting class will make you do it for your children.
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. In this court, communication is key to be successful on probation. If there's an issue, let probation know about it.
Okay.
If you feel they're not addressing it, you can always come back to me.
Okay.
If you feel you're going to use, call probation. I know some courts, people say you can't do that. But in this court, if you call probation and say you're thinking about using, you know what's going to end up happening? I'm going to set a compliance hearing. We're going to come in. We're going to try to address that to get you some help.
Yes,
But
ma'am.
if you don't tell them you need help or you're doing things in secret, nobody can help you.
Yes, ma'am.
All right. Good luck to you. Okay. And thank you for dressing appropriately for court. Thanks, counsel. I love your pen today.
Josh, I work for you.
It's the Courtroom Files Live on a Tuesday. Michael Groff filling in for Dan Soul. Hang out with us in the chat. Go to courtroomfiles.com. Pick up your Courtroom Files merch if you want to become a channel member. $2.99 a month. It's the best value on all of YouTube. And there's a lot of fun. It's a great community. And sometimes, you get to sit and watch me just sit here and fumble my way around through the live show. So what could be better? It is practically free entertainment. Well, it is free entertainment, but if you want to get in on the pre-show and all the some of the benefits that becoming a channel member has for you, then do that. We're hanging with Judge Boyd here while she waits for the next contestant to come down. Otherwise, we'll move on to something else. But let's see what's going on here.
I've got a VR and a trial announcement. I don't know if I can.
So this one. Basically what's going to end up happening. Is this what you're here for?
Yes, in this trial announcement.
Yeah. It's something fine.
Easy enough. We're both already on trial.
All right. And who's your person? Is that?
Mr. Garcia.
Okay.
Yeah.
All righty. 1:30.
Yes.
All right, thank you. John Castro Lopez.
Judge, I do have a victim impact statement to read after this one.
Sure.
We can just do it right here, if that's okay.
Court is calling 2025 CR 0055792. State versus John Castro Lopez. Can I have parties announced for the record?
Jeffrey Wright for the state.
Rafael Leal for Mr. Lopez.
And are you Mr. Lopez?
Yes, Your Honor.
Just one moment. All right, counsel, have you received all discovery? Did you review it with your client?
Yes, sir.
All right, and the court will note for the record that the court previously received an acknowledgement of discovery on July 28th, 2025. There's been no new discovery since that date. Is that correct?
Correct, Judge.
All right. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
State moves to proceed on count 1 and waive count 2.
Any objection?
No objection.
All right, off the record. Deputy Laura, could you have them moved?
They are.
Could you have them not talk so loud? It sounded like it was in stereo coming from this end. All right, we're back on the record. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, your charge is possession of child pornography younger than 10 years of age. As a first-degree felony, the range of punishment is 5 to 99 years or life and up to life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Judge.
Mr. Lopez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, you will be deported and not allowed re-entry and denied naturalization. Did you understand? Court will find that defendant has knowingly voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 12 years in the prison. There are no applications. There's to be Chapter 62 compliance, and there are no contact with defense,
Yes, Your Honor.
state.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? You're gonna have to speak up so she can hear.
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and attachments.
No, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
If you're wondering where the audio is, Judge Boyd is currently reviewing the state's evidence in this case, this horrific case, and so that's why there's no audio here. moment, we'll talk about what's going on in the background behind me here in this picture. We'll get you out to that. A little bit of the breaking news from this morning, but let's see what happens with Judge here. She is taking her time to really review this, though, which we like about Judge Boyd. We like that she's very thorough, but sometimes if you're doing this live and there's no editing and we're not fast forwarding, well, we could actually nudge this forward, but gives us a time to just sort of take this in. This is quite the case. So. All right, we are.
All right, after viewing States Exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty. All right, so why should I follow this plea?
Well, Judge, my client has taken responsibility. He's fully admitted to his actions. Did not play games with the district attorney or the court. I think he's doing that right now, as opposed to dragging this out and making the witnesses and the other people involved to be in court and present testimony. I think it is an appropriate sentence given the circumstances, and also my client has not other convictions, no meaningful criminal record of any kind, Judge.
All right. And then this no contact order that's outside your agreement, that's his child?
Yes, Your Honor.
All right, but isn't there, according to this, on this page,
Oh, obviously there's something very, very graphic that's going on in there. Now I really do want to stick with this and see where this goes. We are in the Wayback Machine a little bit. And so we're going to, I think we are anyway. Let me have a look at this. We should be.
And
there we go. All right.
The child went to a forensic interview and did not provide any.
but there's the photo of his child, so that would be a no.
Okay.
And if that's a deal breaker for anybody, then you can always go to jury trial. But
I explained that to my client, George, and we're willing to proceed.
all right, the court is going to sentence you to 12 years in the prison, give you credit for any time served. Chapter 62 compliance. There's to be no residing in households with minors. No contact with minors. There's to be no contact with anything else with regards to sentencing?
I don't know if I missed it, Judge, but this is a 42A.054 offense. Because it occurred after September 1st, 2023.
Yes.
Okay.
Is there anything else?
Not from the defense.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's plea bargain agreement? Because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. You said there's victim impact?
Yes, Judge, I'll just be reading it off.
Okay.
Oh, I don't think we get to hear the victim impact there. Well, probably for the best in that case. Okay, well, there's lots of thoughts on that. Maybe that's something that we get into on sidebar. Maybe that's something we get into on another day. Maybe we just don't get into it at all. That's horrible. All right. Now, Bailey asking in the chat, what's going on behind me? Well, let's take you back out. This is Jamaica right now. You are looking live. This is near Kingston. And that, of course, you've got Hurricane Melissa with top winds at 185 miles per hour. It does not get any more powerful than that. This is among the most powerful hurricanes that we have ever seen. And certainly it's the most powerful hurricane to ever strike Jamaica. We bring it up here because, well, sometimes we cover these breaking news things here on TCF. Dan becomes your newsman, and since I'm filling in for Dan, well, I guess I'll do it. Nobody else here to do it, so might as well be me. That is incredible, though. You don't really see a whole lot going on there, but you can clearly tell it's looking a little bit treacherous. Let's see. So we're kind of sticking with this for just a second. I just wanted to show you what was going on there in Jamaica this morning. Wow. All right. Well, I think what we can do here. What do you guys say? Well, let's see. Where haven't we gone yet in my time filling in? There's a lot of places we haven't gone. Let's see. Let's say we go to Louisiana. We haven't been there.
Order today is Tuesday, October 28th.
Do we not have audio? Okay. Well, I tell you what, man, we keep breaking the audio somehow. Whenever we go to a different thing here, we seem to somehow we seem to break this audio. Let me see if I can fix it for you guys. Again, I am the fill-in host. I am using other technologies, and I am going to try and fix this right here and now for you. All right, we do this, we do this, we do this, we bring this over here. Something about that, and we click that, and this should work. Louisiana Board of Pardons and Paroles, by the way. Here we go.
Mr. Freed.
Present.
Madam Chair, we have a quorum. Thank you. So our first agenda item now is to review the minutes from Monday,
No audio.
22nd,
Oh, there we
2025. And those are included in your packet. Are there any corrections? If there are no corrections, I'll entertain a motion for approval. We have a motion by Ms. Stapleton and second by Mr. Freeman. Is there any objection? Hearing none, the minutes are approved. And this morning and all today throughout our process, we'll allow public comment on request before any action or vote is taken. Our next agenda item is consideration of applications for clemency and pardon. And our first remote location this morning is at the State Police Barracks. Good morning, Captain.
Good morning, everyone.
Would you and your staff please introduce yourself for the record?
Yes, ma'am. It's just little old me, Pat Washington.
By yourself. And we have Mr. Sykes.
Yes, ma'am.
Good morning, Mr. Sykes. Would you introduce yourself, sir? Tell us your name and DOC number.
My name is Aubrey Sykes and my DOC number is 558058.
Mr. Sykes, I'm going to read some identifying information into the record, and then I'm going to turn it over to Mr. Prater, seated to my immediate right. Your case has been assigned to him. Okay, you ready?
Yes, ma'am.
So Mr. Sykes, you're here this morning seeking the commutation of your sentence. You were sentenced in August 2009 in the 21st Judicial District, Tangipahoa Parish, for a second-degree murder conviction. Is that information correct, sir?
Yes, ma'am.
Okay, thank you. Mr. Pravy?
Good morning, Mr. Sykes. Let me ask you something. And when this incident occurred, tell me about the incident, the motivation for the incident, what's happened since the incident, and how you have bettered yourself to the point where you are now expecting and wanting to be released.
Yes, sir. Whenever I was 16, I engaged in a relationship with both the victim and my co-defendant, Miss Huber. And we had started messing around all through high school sexually. And the relationship between all three of us ended whenever I went to the Marine Corps, whenever I graduated high school. Unbeknownst to the victim, Mr. Brown, I was still in a relationship with the female, Miss Huber. When I completed my training and went to Hawaii, she had called and told me that he was abusing her, which is not true. My father has had a history of domestic abuse with my mother, and I grew up with that. So I got on a plane, I went AWOL, she bought me the ticket with her credit card, and I came home to Louisiana. The day before my crime, April 8th, I called and asked her if she wanted me to shoot Mr. Brown. And she said yes. So that night, I drove to their residence at about 11 o'clock, and she let me in the door. And I asked her, "Are you sure this is what you want to do?" And she said yes. I went into the bedroom and I shot Mr. Brown twice. And then I left and drove and turned myself in after calling my first sergeant. What I did that night, I took away a family. Mr. Brown's family treated me as their own in high school because my family was so broken. I took away a son from a father that loved me like his child, and a mother that treated me and bought me shoes for high school. A family that I betrayed. And it's a pain and a shame that I live with every day, knowing that I took all those things away from him. And ever since then, when Mr. Beal was in the courtroom whenever I got sentenced and said, "Go find God," and he forgave me, every moment since then in prison has been to rehabilitate myself. And every time I've thought about the decision, it would be what he would want me to do. And as a former Navy man, being in the military, to do what you're supposed to do, to be rehabilitated, to better yourself. And when I got to Angola, I didn't have a job trade. And within the first year of getting there, I said, okay, how do I want to better myself? So I started getting into programs, and vocationally, I went to the Angola Automotive Reentry Program. And through my actions of being a good individual and being motivated and talking to others, they made me a reentry mentor by Mr. Gary Young, warden administrator then. During that time, I'm not sure if y'all are familiar with the reentry program, but you also teach people that are short timers how to come in and learn a trade and better themselves individually and how to make money out there in society. And that taught me a lot. And not only there, through taking victim awareness twice, helped me further understand more deeply how I messed up in taking this individual's life. And it could never be replaced. And how it affected so many others, the family, the community, just those around me, and how much pain and suffering I caused them. And it's something I live with every day, thinking about him and the moments he missed every holiday, his mother and father not being with him. And I made that decision with her. And it's something I'm truly ashamed of every day. And I've taken anger management and conflict resolution just to try and better myself as an individual mentally, and through the job skills that I've had through prison as a mechanic, all through my prison record, furthering not only just working on cars, but at the prison enterprise, tractor repair, and here at the state police barracks, furthering myself in all knowledge about from cars to heavy equipment and everything, just so if I ever did get the chance, I would be capable of being able to produce back to society. I could be able to talk and give those that are younger than me, just like in the reentry program, not only a job trade that they could have to be productive citizens, but socially how they could conduct themselves to be better people in society.
Okay. Well, thank you, sir. I appreciate that. Captain, and we'll come back to you with some questions in just a little bit, Mr. Sykes. But Captain, is what he said accurate as far as his attitude and all that from what you've seen since you've been around him? And tell us a little bit about it.
Absolutely, 100%, sir. Each of you have had the opportunity to come here and see the workings of the state police barracks and see how close knit of a family we really are. Mr. Sykes, since I've known him, has been 100% real. There is no question, there is no doubt, there is no wondering what he's going to do when you tell him he has a task to do. If you need a hammer and a chisel, he's not going to ask me why. He's not going to ask me what's the reason. He's going to say, yes, sir. And everybody better be out of this building because he's going to go to work. He's one of the most dedicated individuals I've ever met. One of the most sincere individuals I've ever met. And I am 100% confident that if y'all give him the opportunity to go back into society, he will succeed.
Thank you, Captain. We have 3 people that want to speak in your behalf before we get back to you, Mr. Sykes. We have 2 of them that are here. Debbie Phillips and Mindy Brown are both here and they want to speak. And so whichever one of you would like to go first, if you would go to the podium, please, and speak loudly and take just a couple of minutes, 2 or 3 minutes, and tell us what's on your mind and why you feel like that he needs to get a chance to get out.
My name is Debbie Phillips. I am the mother of Ari Sykes. I write this letter with a heart that has carried so solid for many years. My son has been incarcerated for 17 years. And now that he is being considered for parole, I feel compelled to share what I have witnessed from afar about his transformation, his remorse, and his unwavering determination to rebuild his life. 17 years is a long time for reflection and growth. During this time, I have seen him become a man of humility, compassion, and faith. He has taken full responsibility for his actions and has never sought to justify them. The teenager who entered prison many years ago was misguided, influenced by an older couple, by poor choices and poor circumstances. And that now he deeply regrets. The man he has become today is thoughtful, respectful, and determined to live with purpose. His absence has left an emptiness in our family that words cannot describe. It is a void felt every single day by those who have been. And yet, even through that pain, I have found peace and witnessed his privilege. His dedication to personal growth, his positive influence on others, and his readiness to live a meaningful life beyond those laws. I understand the seriousness of this crime that led to his incarceration, and I do not ask for forgiveness without accountability, nor leniency without understanding. I ask only that you recognize his proven growth, his record of good conduct, and the unwavering support of me and his family. I ask that you see his humanity and his sincere commitment to redemption. Continued incarceration would not further the goals of justice here. Instead, it would deny a reformed man the chance to put his transformation into action and to contribute positively to society. I truly believe that if granted his freedom, he will not waste it. He will honor it with gratitude, with purpose, and with service. The grief of a mother watching her child taken away is a pain beyond measure. I still remember the day of his sentencing. The tears that would not stop, the fear of how he would survive behind bars. In the years since, I have prayed daily, not only for his safety, but for his healing. And I believe those prayers have been answered. This letter comes from the depths of a mother's heart, but also from a place of reason, reflection, and faith in the power of rehabilitation and redemption. I have faith in your wisdom and in the justice system's ability not only to hold individuals accountable, but also to recognize genuine transformation in this case.
Thank you, ma'am. We appreciate that. Appreciate your words, very succinct and what we need to hear. Okay, let's see, Mindy Brown, would you talk to us, please?
Yes, sir. To the honorable members of the Parole and Clemency Board, my name is Mindy Brown. I'm the sister of Aubrey Sykes and the sister-in-law of the victim, Slender Brown. I'm writing to you with a heavy heart, but also with hope because I have witnessed my brother's profound transformation and remorse. The circumstances surrounding this case were extremely complex, and while none of it excuses what happened, it explains the pain and pressure that Aubrey was living with under this time. Aubrey was always known to have a kind heart, the willingness to help others. On the outside, he was a motivator, he was a friend, a hard worker, and the smartest kid that you have ever met. He was loved by everybody. But what I need you to understand today was that on the inside, Aubrey had a lot of pain, fear, undeniable shame of things that he couldn't control that were happening to him. We grew up in a home full of violence, chaos, and daily abuse. From a young age, Aubrey endured both physical and sexual trauma and abuse from people that he loved and trusted. There was constant fear, neglect, and exposure to drugs and alcohol. We spent many nights in our car in a church parking lot, watched everything we owned set on fire by his own father, and even shielding ourselves behind an oak tree in our own front yard as his father tried to kill all three of us with an AK-47. Our lives were in fight or flight from sun up to sundown. Aubrey learned to defend himself and the three women that he protected every single day as the only man of protection. His father was extremely abusive and unstable. As children, we had no sense of safety or guidance. My brother carried that weight with him and that trauma for years as it deeply affected him in ways that I don't think he even understood at the time. Fast forward a few years later to 2000, and Aubrey finally found a family, my in-laws, that loved him and he loved them. He finally found a respected father figure in my father-in-law, Bill Brown, and he loved Aubrey. But that didn't last long, because yet another adult would soon come into Aubrey's life and tear him down and destroy what he loved for their own personal gain. The crime that led to Aubrey's incarceration was not the act of a hardened criminal. It was a young broken boy who was groomed and manipulated by multiple adults in his life. When Aubrey was still just a minor 16 years old, a woman, Brooklyn Huber, took advantage of his vulnerability. Through befriending me as a sister-in-law, she knew our story. She knew his pain. She knew his insecurities, and she gained access through me to Aubrey. She preyed on his youth, his trust in her, and his vulnerable emotions. She did this with money because she knew how poor we were growing up. She used drugs and alcohol to control him. She used sex because she knew of his innocence. By the time he was 18, he was already deeply entangled into a situation that no teenager should ever have to face. Aubrey decided that going into the Marines was a great idea to escape this love triangle. While serving a short time in the military, she continued to control and influence Aubrey until it worked and tragedy struck. When everything happened and the realization of his actions formed in his mind that night, shortly after the incident, Aubrey didn't run. He turned himself in immediately and faced what he did. Aubrey has never denied what happened, and he takes full responsibility for his part. After Aubrey went to jail, our baby sister Marissa couldn't cope with the pain and the loss of what had happened to our family, and we lost her to suicide at 22 years old. But through all of this, Aubrey has found faith and relied on it. Aubrey has spent the last 17 years dedicating himself to change. He has become a man of faith by accepting Jesus Christ as his Lord and Savior, disciplined by no problems in prison, making trustee at Angola Rodeo, showing compassion to others. He mentors about the importance of positive behavior in prison, teaches others valuable skills, and has earned certifications to better himself. He has faced the consequences of his actions and turned his pain into meaningful purpose. He even had the honor of serving and working for 2 Louisiana governors, where his hard work, honesty, and continued respect earned him great trust with 2 of the most important men in our state of Louisiana. As a mother myself of now a very vulnerable 17-year-old, I can truly see the impact of negative influences on teenagers' lives from a whole different
Ms.
perspective.
Brown, time out just a second. You kind of wrap your remarks up.
Yes, sir, I'm almost
Would
done.
please, because we tend to ask him and he'll go over a lot of the
Okay.
things that you're going over.
Yes, sir. If given a second chance, Aubrey has a full-time job waiting for him. He has a stable home, continued counseling, and support from others. Please consider Aubrey's traumatic circumstances of his upbringing and the manipulation he suffered as a child and a teenager. He has paid a very heavy price for mistakes that stem from situations far beyond his understanding. All I ask is that you look at the man Aubrey is today sitting in front of you and not think that he was when he made this mistake. I believe with all of my heart and soul that my brother Aubrey will never be a repeat offender. 1 John 1:9. If we confess our sins, he is faithful and just and will forever give us and will forgive us of our sins and purify us from all of our unrighteousness. Thank you from the bottom of my heart for your time, your compassion, your service, and most of all, believing in redemption.
Okay, thank you. Didn't want to cut you off, but we do have a lot of cases today, and we have read probably 300-400 pages each of us about this case. We're very familiar with everything, testimony and all that. Mr. Blake, would you tell us what parole project has in store should he be granted this opportunity?
Yes, sir. Good morning to this honorable board. Channing Blake with Louisiana Parole Project, appearing on behalf of Mr. Aubrey Sykes. As previously stated, he has done a tremendous job while incarcerated. He's been ASC certified, reentry mentor, minimum aid trustee because of his program, and he has had no write-ups in his 17 years of incarceration. He's worked in trusted responsibilities, and because of these factors and many others, we've accepted him into our program. Should the board give him a favorable recommendation, we're going to provide him transitional housing, employment assistance, social norms, and many more. So based upon his record and his rehabilitation, we ask that you grant him a favorable recommendation today. Thank you for your time.
Thank you, Blake. We appreciate that. And there are nobody here to speak in opposition. So, Mr. Sykes, let me ask you a few questions. At what age did you start having a sexual relationship with this lady?
16, sir.
15?
16.
16. Okay, thank you. And so tell us why did you do this?
I had seen at the time when she told me she was being abused, a woman in pain. And it hurt in my heart to see someone that I loved at the time, that I spent so much time around, in that kind of pain. And whenever I came home and talked to her, and she said it would never end, the decision was made for me to shoot him. And it was a horrible, shameful thing. And I just didn't want to see the hurt in her voice. And that was the only way at the time I could see to make it end. And it's something I think about all the time, about the choices that he doesn't have today, or the experiences he doesn't have today because of my action of murder. And I regret it.
And is it not correct that she is still in jail at this point? Correct?
Yes,
for her party?
Yes, sir. She's currently housed at whatever the women's facility is for DOC.
Okay.
Life sentence. Yes, sir. She's incarcerated.
How many write-ups have you had since you have been incarcerated?
None, sir.
That's amazing. You realize that, don't you?
Yes, sir. Yes, sir. But I've always thought about what Mr. Bill, the father, want me to do, and follow orders, be good, and just do anything to advance yourself better as an individual.
Okay. All right. And so we don't have to go over your classes and your certificates and work experience. I think all of that's in the file, and the captain, of course, we trust the captain implicitly. So anyway, I don't think we need any of that. Let me look at my notes and see if there's anything else I need to ask you. And I think I'm satisfied with all of those questions. So Madam Chairman, I will turn it over to you to.
Any other questions? All right, I don't see any other questions, so Mr. Prater will call for the vote.
Okay, I think this is a highly unusual case, as are all of them. But this is, I guess if there's such a thing, exceptionally unusual. And so I think that's where we find ourselves here. I think with your experience, with the fact that you were actually groomed in this particular case, with your attitude and conduct, I don't think that for you to leave today thinking that you've got to spend the rest of your life in jail and there is no hope, I don't think that's appropriate. I think our board is supposed to vet things like that and to look and try to find the ones that are truly rehabilitated. I think that I do want another board of the parole board. We're the pardon board. I want the parole board to take a look at you, and I want the governor to take a look at it. And so my vote and it's just one vote out of the 5, and it's just a recommendation to the governor, so it's ultimately his. My vote is that you would be, that your sentence be commuted and that you are immediately eligible for parole, and to come back before the parole board and see what they think. That's my vote.
Mr. Freeman?
Okay, this is a very unusual circumstance. My vote today is going to be to commute to 99 years with immediate parole eligibility, based on what the warden said about you, warden. I appreciate those comments, and I do think he would tear down a building for you with a chisel. So
Thank you, sir.
that's my vote.
Mr. Tillman?
I concur with Mr. Prater and Freeman.
Mrs. Stapleton? I concur with Mr. Prater. All right, Mr. Sykes, I enjoyed listening to you and your family today and what all the captain had to say about you. I too will vote to make that same recommendation to the governor. And my vote is based on, this is your one and only arrest ever. Your age at the time of the crime. And I think you have surely demonstrated growth and maturity. You've done service to others, and you have a remarkable record. So we will make that recommendation on your behalf to the governor. Good luck to you, sir.
Yes, ma'am. Thank you, ladies and gentlemen of the board.
Captain, I think that concludes our business there. We're going to sign off at 9:28. Thank you, sir.
Thank you.
All right. Well, it's not denied and it's approved. How about that? Don't see that too often from the Louisiana Board of Pardons and Paroles. So that's good to see. All right. We are clearly into just a skosh of overtime, but why not? Why not have a little fun? We'll continue into just a little bit more overtime, a bit of a palate cleanser. Let's take you out to, 9 to 11% more Judge Boyd. So let's see what's going on.
State versus Jesse Orozco. And Norma, find out how many witnesses they have on Miller. All right, and where's your client?
It's in the tie. I'm over here, I think.
Okay. Ask the state how many witnesses they have. All right, are you Mr. Orozco?
Yes, ma'am.
Counsel, have you received all discovery that you review with your client?
Yes, I have, Your Honor, I have.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Orozco, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving the punishment.
Any objections to?
No objections.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge is possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe so, yes.
Mr. Orozco, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and reentry?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 60 days in the Bear County Jail. Under 1244, there are no applications. There's to be restitution of $180 to DPS for testing. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No.
Then how do you plead to the offense?
Guilty, Your Honor.
State any evidence?
State offer states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has been sober now for a few weeks. He started taking care of himself that way. He's willing to do the time, and he's set up meetings with AA. He's got a sponsor now. Is that right?
Yeah, it's a good month.
But I think that he just wants to get this time done and then move on from there. Your Honor.
Anything you wanted to tell me?
I'm just, I made a mistake. I wasn't making wrong choices at the wrong time, Your Honor. I'm fully accountable of my mistakes, and I'm trying to get forward with my life.
All right, and how are you maintaining your sobriety?
I've been attending AA meetings at the Club 12, Your Honor, and I've asked everything of the pretrial investigations of me to be doing as a monthly UAs. I've passed every UA. It's been 12 months now. I have not failed one time. I had my head in my rear end at the time, and I just I fully accept consequences of my actions.
And so how much time does he have in?
9 days.
Okay. All right, so they're going to take you into custody today, okay?
Yes, ma'am.
All right, the court will follow your plea, sentence you to 60 days in the Bear County Jail. You credit for any time served. There's to be restitution of restitution of $180 to DPS for drug testing.
Okay.
Did you review the document entitled Trial Court Certification?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. First of all, I want to thank you for dressing appropriately for court. Even though you knew you were going into jail, you still dressed appropriately for court, and I really do appreciate that.
Well, Your Honor.
With regards to your sobriety, don't let anybody get you off track with your sobriety, right?
Yeah.
When you're released from custody, if you have any problems, you can come back here, okay? And then I'll pick up the phone and find some place to help you, all right?
Thank you, Your Honor. I appreciate that.
Now, here's the thing, the jail, if you're a trustee, they're supposed to give you credit. Every day you serve, they give you 3 days credit. If you're just in general population, not causing problems, every day you serve, you get 2 days in credit. I'm not in charge of that. So if they're not giving you credit for 3 for 1 or 2 for 1, you just have to address that with the sheriffs, because I have no jurisdiction over that, okay?
Thank you, Your Honor.
All right, good luck to you, okay? I'm
Thank
so
you, Your Honor.
glad. You look clean and sober. I like it.
Thank you, Your Honor.
You're welcome.
Appreciate it, Judge. Oh, can I have one more case in the dockets on the trial docket?
Mhm.
It's been re-indicted,
Mhm.
Jamar Clark.
Mhm.
And I was gonna see if I could just take my 10 days and be released.
Just give me a moment. Let me do this
Yeah.
real quick and I'll take that out. Dejanay Miller. Dejanay Miller, Havana.
Sorry.
All right. Are you all ready?
Yes.
All right. Court is calling 2025 CR 001-454, State versus Dejanay Miller Havana. Can I have parties announced for the record for the state, for the defense?
Jody Sawyer's for defense.
And are you Dejanay Miller Havana? All right, you entered a plea on September 30th of no contest. According to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The state is opposed to your application of deferred adjudication. The state is recommending community supervision. Outside the agreement, there's a request for your community supervision to be for a term of 10 years. And of course, community service hours and different programs. Have both parties had a chance to review the PSI report and the TAP evaluation?
No. I have.
Oh, you have not?
No, Judge.
All right, so I'll have you all step back. So if you can review that and just come back up once you reviewed it. All right, thank you. All right, the parties on Robert Moreno.
Judge, I have two short witnesses for the court.
Right. Court is calling 2025 CR 008-569 and 2025 CR 008-203. State versus Robert Luis Moreno II. Can I have parties announced?
Austin Stout for the state. Jim Oltersdorf for Robert Moreno.
And are you Mr. Moreno?
Yes, ma'am.
Yeah, all right. Man, that's a long time. Objection, sir, to appearing by Zoom?
No, ma'am.
Yeah.
Defense, do you have any objection to your client appearing by Zoom?
No, Your Honor.
All right, according to your plea bargain agreement and cause number 2025 CR 008-569, punishment is being assessed at a cap of 13 years. And cause number 2025 CR 008-203, punishment is being assessed at a cap of 13 years. And each cause number, the state is opposed to your applications. All right. Have both parties waived the PSI and the TAP evaluation, is that correct?
Yes, Your Honor. We were present about a week ago, I believe. I can't remember the exact date. That's right. We did.
All right. Defense, I'm sorry, state, do you have any witnesses?
No, Your Honor.
Defense, do you have any
I
witnesses?
do, Your Honor. May I call my first witness?
Yes.
Mom, could you come up, followed by Joanna, I guess. It's okay, don't hurry. Right in this spot here.
Hi, I see that you're lipping. Do you need a seat?
No, it's no. It's just something I live with.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
My name is Joanne Esparza.
All right, you may proceed.
Thank you. I'm sorry, I mixed up the names again. Now, you're Robert Moreno's mother, is that correct?
That's correct.
And of course, I want you to make sure the judge can hear that.
Yes, that's correct. Robert Moreno's
Now,
mother.
Robert has been in court and he's been here present in person before in the courtroom in a wheelchair. Can you tell the judge what his medical condition is?
Robert was born with spina bifida and hydrocephalus. He's been paralyzed since birth. He's had a BP shunt. He had reconstruction on the spine, but stayed paralyzed. He's had a BP shunt in his head. 3 months, a replacement at 9 months and 9 years. And the doctor stated that there would be like maybe 3 replacements throughout his lifetime.
I'm sorry, go ahead.
Robert has always been a sickly person, sickly child, in and out of hospitals, surgeries, doctors. The last one was the worst one. He's had tailbone surgery from not being in a proper wheelchair, which we have to fight to get. And I've always been his caretaker. I've always taken care of him, nursed him back to health. And the last one was the gas gangrene. He's got incontinence problems, which he takes medication for, but he still has some leakage problems and has problems with his bowels. With the leakage, I guess it broke his skin and he winded up getting gas gangrene. They did a flap surgery in his groin area and abdomen. And while he was here in jail, it reopened, and that's something that we always have to look out for, like a tissue breakdown. He has problems with his bowels as well. Like I said, I've always been his caretaker, along with my sister being my right hand, you could say, his second mother. And I just want to let y'all know, I plead for mercy that if in any case he'd be able to be on probation, he reside in a home where there is no children, no internet, no use of a phone. He'd be under supervision at all times. I work in the morning, my sister works at night. We don't know how something like this could have occurred. We didn't see it coming, and it came as a shock to us. We only knew the very minimum. And we would like to get him help with counseling to resolve this problem. But he's always going to have health issues. He's always had health issues, and how he's done it by so far, I don't even know, because I've always had to even help him bathe, cut his toenails, and look out for pressure sores. I've always been the one.
What kind of work do you do right now?
I work in fast food.
Okay. Judge, I have tendered to the state medical information. I'd just like to be able to have it in the hands of the court to more or less verify. It's recent. That's what I was asking. I didn't want to get piles and piles of information. We have a lot that goes back a long way. I wanted you to at least know that his condition is not temporary. In other words, it's not something that somebody has come into court and said, well, Judge, I need to be on probation, and then they more or less get up out of the wheelchair once they get what they've asked for. This obviously, based on what the medical stuff that I have, this is, like I said, it's been provided to Mr. Wright, not Mr. Stout, but it's in their file. Verification of the spina bifida, which, as you know, is the spine born, a child born with the spine outside the body. And it's not something that's, going to go away. So his mobility is, of course, limited. And of course, I can't absolutely, and I've gone over this at length with his mother and the next lady that would ask you for your attention. How did this happen? And again, told them that what the court would expect to know is that this could never happen again. So I think we've at least closed off one avenue for purposes of any question of being a sexual predator. If he doesn't have the ability to go out and go to places, schoolyards or out in the park or anywhere like that. So the next question, of course, in my mind for a judge that I would want the judge to know, and I know always consider, first thing we think of is, well, if it happened before, it can happen again. And I've tried to make sure that she understands, and she seems competent as far as her insight and explanations and knowing that this cannot be explained away, but it has to be stopped. And because it is something that might continue, we want to make sure that any communication that would enable him to do anything like this would be cut off. And she is here to tell you about that and to try to promise you that. The only thing that I can't stand up here and make sure that you know about is we're not really sure what to do with regard to some type of 24/7, because as you've heard, you do continue to work, correct?
I work in the morning and my sister works in the evening.
Okay. Would there be any time?
That he would be alone now.
Yeah. Okay. So the judge can be assured that someone will be there to not only take care of him, but to prevent him
Correct.
from being on the internet or having phone contact
we have no internet to begin with, and he wouldn't have any access to any telephone.
Okay,
Because
so,
he would always be under supervision, so we'd always,
so before, when there was a need maybe for a telephone, I'm just guessing, if someone in a wheelchair, let's say a fire breaks out, things could come up where they would need to contact 911, for example.
correct, but he'd always be supervised.
Okay, so there wouldn't be a need for that anymore because he would never be left alone. That's the assurance you're giving the court?
Yes.
Thank you. Pass the witness, Sean.
Any questions?
Yes, ma'am. I'm the prosecutor in the case, Mr. Scott. Just a few questions. You were Mr. Moreno's mother?
Yes, sir.
Okay. And back when this incident occurred, he was around 19 years old. Are you aware of that?
No.
What is your understanding?
I understand it was several years ago. 2018, 19, 20, about that time. And as far as I knew, I thought it was just contact like on the phone, like they were talking and stuff like that. So when the attorney spoke to me about everything, it came as a quite a shock I didn't have.
So at that time, was he residing with you primarily?
Yes, he's always beside me.
What was he doing at that time? Was he working, going to school?
Going to school.
Okay. And how are you related to the victim in this case?
She is my niece.
And you understand that she was 9 years old when this happened?
I don't remember what her age was. They had told me that she was, I think, 13, is what I had heard.
I'll pass the witness.
Well, just to make sure you're completely
Yes, but I
aware.
understand what was written.
Okay, you understand, you and I have carried on many conversations about the discovery, meaning
Yes.
the DA's
Yes,
file.
everything that's come out.
Okay, so
Correct.
you're basing your information now on
On
what you discovered and how to prevent it from
Yes, sir.
happening again, correct?
Correct.
Thank you. May I call my next witness, John?
May I?
Oh,
ask
yes, Judge, I'm
the
sorry.
objection?
No.
All right, so
Oh, miss.
Yes, ma'am.
no. I want you to understand something. One,
Yes,
you keep it in an open mind and I'm listening to everything. But sometimes when people are called as witnesses, they're asked, oh, how can you make sure that this person follows the rules? That's really not your job. It's the person who is on probation of all of the rules. And so according to the stipulations that I've read, this started when she was 7. And then the photos that are in the stipulations is that they're saying they're photos that depicted young children and infants. Now, with regards to the infants, I don't know if that was pornography or sexual in nature, but that's what it says in the stipulations. And that's when they said they were making inquiries as to what was the age range for his sexual interests. So I just want you to understand that I'm listening to you, but I'm also, I've also reviewed the stipulations as well. So none of this is your fault. And your testimony gave me great insight to his medical issues, okay?
If I may add one more thing, Judge. I've had no contact with my niece nor her family since all this first came out.
Mhm.
But I still love her, I still care for her, and I do hope that she is getting some kind of counsel for her,
Because in the
I know
stipulations.
how drastic it is.
Yeah, because in the stipulations too, it says that he continued to reach out to her. And then there was some blocking going on. So I
That's
just
what
want
I
you to understand the full extent of things and everything that I'm considering, okay?
Yes,
But thank you so much for your testimony. I appreciate
Yes.
that. Thank you.
God bless you.
Oh, thank you. God bless you too. Call your next witness.
Where are you? Yeah, thank you.
Hello, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Judge.
All right, you can lower your hand, state your name for the record.
Rosemary Esparza.
All right, defense, you may proceed.
How do you know Robert Moreno and his mother?
He is my nephew and she is my sister.
Okay. Now, I don't I don't think you could hear from back there, but we were talking about things that I've talked to you all about, both of you about previously, about how can we give some type of reassurance to the judge with regard to controlling this contact and with anyone. You understand what I'm talking about, remember?
Yes.
We discussed it more than once, last time in the witness room a few weeks ago. She was talking about, his mother was talking about monitoring, and we realized that it's something that would require more or less 24 hours supervision. You know what I'm talking about?
Yes.
Can you talk to the judge a little bit about your ability to be a part of that, and maybe what your hours could be, what you've talked about with your sister, about what needs to be done to make sure this doesn't ever happen again with anyone?
Judge, basically, she clarified everything. I know we're not above the law, no one is, but I do pray for my nephew and my niece.
Do you, excuse me for interrupting, do you work?
Yes, I work at night,
Okay,
and my sister works in the day.
okay, so
We,
I'm sorry, just to take it from that point. We were talking about a 24-hour day situation.
yes.
Do y'all live together?
No, but during the time before Robert Lewis got arrested, he was staying with me. He
Okay,
was living with me. My sister would come and stay with us. And we've talked about it. If it came down to it, that I would be willing to open my home to them.
okay. So are there any children in your home?
No,
Okay,
there's no children, no internet.
so it would be the three of y'all, Robert, your sister and you, or do you have a husband, or how does that work?
And my father,
Your father, okay. So you work at night. What kind of work do you do?
I'm a housekeeper,
Okay.
hospital,
At where would that?
Santa Rosa,
Where?
Santa Rosa,
The Santa Rosa Hospital? Okay, thank you. How long have you been doing that?
9 years.
9 years. So that's from what time roughly in the evening do you start, and when do you get off?
I start at 3 and I finish by 11:30.
Okay, so 3 p.m. and that's in the afternoon,
Yes,
11:30 p.m. at night, right before midnight?
Right.
Okay. And so you could come back home after that and monitor Robert and make sure, like you said, there's no internet and he has no phone. Is that correct?
correct.
Okay. So he would be cared for, and his medical condition is something that you have probably been aware of for his whole life too, correct?
Yes, correct.
What would that be? What is his medical condition? You understand it?
Yes, I understand it. He has spinal bifida.
And that is something that he was born with, or did it?
Yes, sir. He
Okay.
has spinal
So his whole life he's been in the
wheelchair bound.
condition that he's in now, except he's had different medical issues come up, I believe, right?
He's always getting sick. My sister's always in the hospital with him.
Okay. So I'm not going to ask a lot more. I'm just trying to make sure that the judge knows it's the picture that, of what is visualized here, which sounds like the assurance that she's got that he's not going to be in a position, even if he wanted to do this again. And do you know, one more thing, do you know the niece that we're talking about here?
Yes, I do.
How do you know her very well, or?
Very, very well.
Okay.
I practically raised her.
Okay. And you know about the facts of this case, and you were surprised as well, I believe,
Yes.
correct?
Yes.
Okay. Now, as Robert goes forward, we hear about things like bed sores or whatever. You sound like you might be familiar with that if you work at Santa Rosa, right?
Yes.
And you've been involved in, as a housekeeper, are you involved in helping people in a nursing situation, or just what is extent of your duties at Santa Rosa, just briefly?
No, so it's just securing, the safety for
Okay.
patients and.
Okay. Do you deal with patients at all?
No,
Okay. But you're totally willing to help
yes.
in any way with Robert's medical conditions, no matter what they may be, even if it's,
I've helped out taking care of Robert.
Okay. thank you. The judge may have some questions. Go ahead.
Any questions?
Nothing from the state.
All right, thank you so
That's all we
much
have.
for coming down.
Thank you.
So I want to let you know, I've heard everything that you've said, I've internalized it. And I'm considering everything and in reading stipulations, even though he has these medical conditions, you're aware that according to the stipulations, he did engage in physical contact with her. And according to this, he also threatened, according to the stipulations, he threatened to go after her younger cousin if she didn't send him photos and if she didn't do other things. You're aware of that? Okay, all right. Thank you so much for coming in. I appreciate it. Yeah. Any other witnesses?
May I ask Mr. Reno to
Okay,
explain briefly?
all right. If you can unmute yourself, please. You want to raise your right hand? You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Robert Moreno.
All right, defense, you may proceed.
Thank you. Robert, you've been listening to your mother here today. And how do you feel about you've admitted that you by entering a plea, even though it may be no contest, you've admitted that you've done these things.
Yes,
correct?
I'm on the case from like 2004.
Correct.
I got like 20 months left on parole.
Do you feel like that you did something wrong that you shouldn't do again? Can you hear me?
I do. I'm deeply ashamed. I promise I won't do anything like this again.
Do you have?
I'm sorry, you're breaking up a little.
Okay, well.
Like I said,
Robert, with regard to being on probation, is there anything you'd like to say to the judge before she makes her decision about why you should have a chance to be on probation? Will this ever happen again? Are you sorry? Tell her what you think about everything that's going on here in your life with regard to this offense.
Right. Well, as I said, I am deeply ashamed of my actions. I was young. I was very dumb. I made mistakes, and like I said, I'm ashamed of my actions. I feel for my family as well. As they said, this came to a shock to them, and I apologize to them, for putting them in this position. I want to thank my family for standing by me through this situation as well. As for your consideration for probation, I appreciate you taking into consideration everything, Judge. As my family said, they would set up a scenario where I would be under their supervision practically 24 hours a day, no internet, no phone, no way of contacting
Robert,
victim or anyone that could be a victim. Yes, sir.
Robert, with regard to your medical condition, kind of on a timeline going forward and using the past as a reference point, are you receiving the kind of care in the jail that you had received before you were put in jail?
Not to the extent that I was previously to jail, no.
What, without getting into details.
I have been receiving care, but it hasn't been.
Pardon?
Oh, if you could repeat that last answer, sir?
Well, let me ask it again. Are you receiving the kind of daily care or whatever is required that you were receiving outside? Are you getting the same kind of care and attention as you were in jail with regard to your medical needs?
Not to the extent that I was before being arrested.
What, on a weekly basis, just a kind of an overview, do you need something done every day with regard to you being assisted in your wheelchair since you're paralyzed?
Yes.
Is that happening? I'm sorry.
I use stuff catheter.
I understand. It's okay to talk. We need to know.
Catheters. I use them daily, in and out catheters.
Okay.
I also, and sometimes those, the nurse will skip a day, won't be able to supply them for that day, or I'll ask and they'll get busy. So usually I won't, every once in a while, I won't get what the materials that I need in order to make sure that I can remain healthy.
Is it harder in jail, just taking away the fact that you're in jail, is the medical attention, is it less than you received on the outside, even though they try to keep up with what's your needs are?
Yes, I understand that they have other inmates and other patients that they have to tend to, so the amount of care that I receive personally is not to the extent that I received before jail.
Okay, I know you're getting medication. I've checked on that, correct?
Yes.
I'm talking about other types of things such as cleaning and the like, medical attention.
Yes,
That's good or bad?
It's not to the extent that I wish it would be, the way that it was before.
Not the same as with your mother and your.
Correct. My family was much more thorough, and they would be able to be more thorough and keep my health in tip-top shape.
Thank
Whereas
you.
here, I would just like to mention that I've had several breakdowns, not just the one that my mother knows about. So I've been receiving wound care here and there throughout the 8 months that I've been here.
It was just a request, like a little request.
Do you require outside doctor care that you have or have not received?
Yes, I have a, well, like I said, my mother said, I have the VP shunt in my head. If that were to break down, or if that were to be damaged, I would need surgery for that. On top of that, any wound care, we would have nurses that would come and supply the medical equipment and show mother how to dress a wound.
Now, the BP, what is it? Just real quickly, what does that mean?
So it's from the hydrocephalus. I don't know what the acronym for VP stands for, but basically it's a catheter that goes from the brain down into my stomach, and it allows the fluid to flow properly. Without it, my head would swell up, cause headaches, and eventually death.
Okay, so this has to do with fluid from the brain that has to be removed, or what?
It has to flow throughout the body, otherwise it would swell in the brain.
Okay, otherwise the brain swells?
Yes.
And you've had that at least once in your life already, right? Done?
I believe I've had 2 replacements so far.
2?
I believe so.
Okay, it's called a stent, right?
I believe so.
Okay, do they drain it at the jail, or how does it, a stent usually means something is inserted or drained?
So it doesn't need to be drained. What it does is it flows through in and out, and as long as it isn't damaged and there's no leakage, then there's no need to drain it.
Okay.
But if there was damage to the shunt, then drainage would be necessary, and then surgery as well.
Robert, there's a gentleman standing over to the on your screen. He's from the DA's office. He's not Mr. Wright, who you've met, but he might want to ask you some questions on behalf of the DA's office, okay?
Okay.
All right. So answer his questions appropriately. Thank you.
Yes, sir.
I've never had a.
Mr. Marino, before your arrest, where were you receiving most of your medical care?
Oh, keeps pushing. Keep adding.
Mr. Moreno?
Time you do on the streets, add it back on, you know, like.
Can you hear me?
I've had a felony since 2004.
I apologize.
All right, Mr. Moreno, the question from the state was, before you were arrested, where were you receiving your medical care?
My primary care physician is Dr. Federico Praduo. I was receiving care from his office as well as partially through wound care center. Whenever I had a breakdown, they would help us out with that.
And what hospital were you going to for treatment when you needed?
And for the hospitals, I was going to Baptist Hospital.
Okay. And you understand that in the jail, you have a right to the medical care for any
Yes.
issues. Okay. Just going to the facts of this case, I know you stipulated the evidence in the case, and that evidence alleges that you touched your cousin when she was very young, correct?
Right.
On multiple occasions. Correct?
I don't recall.
More than one occasion?
Multiple occasions, but if that's what it says, then.
And well, you would have the best,
I don't
you have to be the best person to know that information, correct?
You know, like I said, I'm from Houston. I'm from Harris County, so.
And how old was your cousin when this occurred?
3 sisters.
From my understanding, she was on the age of 13. But the stipulations state otherwise, so.
So you disagree with that aspect of the stipulations?
Correct.
Okay, how old were you at the time?
Roughly 20.
Last year.
2022.
And then you've also
In that
stipulated
range.
that you engaged with her online, correct?
Correct.
I just got.
And
I got
how old
into
was
it
she
on
when that
Wednesday.
occurred?
Thanks, Lord.
To my understanding, around the age of 13 as well.
Go get an address.
And so it was around the same time?
Didn't do it. And, you know.
Yes.
Everything just blew up.
Okay.
I was
And
really
your,
moving too fast, trying to get into a
Your
relationship.
position is that you did
I
not
was
send
just
any
gonna do
photographs
some
to
of
her,
last
but that
year,
she
matter
sent
of
photographs to
February.
you. Is that my understanding?
Correct.
And why would
Yes,
she
that
do
is
that?
correct.
Why would she do that?
I was, for the last time, 5 years, I took 6 class. Drug treatment and I
I
successfully completed it.
basically convinced her to do so.
Like I said, I came out running, man. Got
She,
my-
I guess,
I
felt
was in trouble.
like it was necessary. Otherwise, she might get in trouble or I'd tell someone. I'm not sure.
That was 700.
And so you're the one that made her do that.
I got
Yes.
2 more times to take.
And did you threaten her as the
So I
stipulations?
came out running. I had a job that
detail?
No, I didn't threaten her.
Positive, you know, but when you
Okay,
hang
so
with
that
wrong
would be,
people,
if she
it's
said
like,
that, she would not be telling the truth.
you said,
Correct.
And guess what?
Do you realize the emotional harm and trauma that you've inflicted on this young woman?
I do.
And do you have any children, Mr. Moreno?
No, I do
I
not.
understand why.
If you did have a daughter and this happened to her, would you think that probation would be appropriate for someone that had done that to her at that age?
Get where I'm at now.
Okay, pass
Not
it.
necessarily.
All right, any other questions?
No, Your Honor.
All right, thank you, Mr. Moreno. All right, any other witnesses for either side?
No, Your Honor.
All right, in cause number 2025 CR 008203, the court will find you guilty, sentence you to 13 years in the prison, give you credit for any time served. There's $1,000 fine, time and money to run concurrent. This is run concurrent with 2025 CR 008569. There's to be Chapter 62 compliance. There's to be no contact with minors, no residing in household with minors, and no contact with the complainant. And cause number 2025 CR 008569, the court is finding you guilty. The court will sentence you to 13 years in the prison, give you credit for any time served. There's $1,000 fine, time and money to run concurrent. This will run concurrent with 2025 CR 008203. There's to be Chapter 62 compliance, no contact with the complainant, no residing in household with minors, no contact with minors. Is there anything else with regards to sentencing?
No, Your Honor.
And each cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Mr. Moreno?
Yes, Your Honor.
Because
Just
these are
go
plea
on.
bargaining agreements, because I followed your plea bargaining
You
agreement,
sit
and
me
because you
down,
waived your
sit me
right.
down and tell me, look, I got a better thing for you
Yeah.
than what you in the street.
Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. So I want you to know, Mr. Moreno, your attorney did a great job for you. I did take into
So
consideration
then I see, I never involved myself in it, so I
medical
stayed on
issues that you
the-
have. That is the reason why I didn't ask either party why I should accept your plea bargaining agreement. So good luck to you, sir.
Thank you.
Thank you.
Thank you.
All right, the court is calling.
Wow, that is quite the case. The guy has spina bifida. Clearly, karma has already caught up with him in terms of a sentence. And so there's that. But my goodness, what a case that was. My intention here was just to go a little bit of overtime, maybe to the bottom of the hour, but obviously that case went on quite a while. And if you're wondering about the background audio in that was from Mr. Morero's audio over Zoom. That had nothing to do with what went on over here. Okay, I think with all of that having been said, we did a lot of overtime today, super overtime, in fact. And let me see something here. Let's get you a look at what's going on in Jamaica, if I can. There we go. That's the scene right now from near Kingston, Jamaica, as they have been battered by Hurricane Melissa, one of the most powerful hurricanes we have ever seen. And if you want to find out more information about weather stuff, which apparently nobody else did because today's video did not get very many views. But anyway, if you want to get more information on all of that and everything else, it's... I'm choking up. It's the Phoenix, Arizona weather discussion. Oh, it's been that kind of morning over on YouTube. I didn't have a drink. What a time to choke. All right. Anyway, thank you so much for watching. One more thing here. Tonight, 8 p.m. East, 5 p.m. Pacific, sidebar right here. It has been kind of a morning. Anyway, 8 p.m. East, 5 p.m. Pacific for sidebar right here on the Courtroom Files YouTube channel. And we'd highly encourage you to check that out. Oh my goodness, what a morning it has been. Okay. And tonight, what are we talking about? Just tune in and find out. That's all I'm going to tell you about that. There, we'll put that on in the background so you can see what's going on in Jamaica as I get all choked up about all of this. Thank you again to Bailey, Wahoo, Ashley, Mama TCF, Grandma TCF, Mama Joan for all the super stickers, the super chats. Really do appreciate it. Really, it's been a great time here the last couple of days, and we're filling in. We got 8 more of these live shows, and then we've got sidebar again tonight, 8 p.m. East, 5 p.m. Pacific. Join us tomorrow morning, 7 a.m. Pacific, 10 a.m. Eastern time, 45 minutes early for channel members, because Dan will be on for the pre-show. If you're a channel member, he may join us during the live show at some point. And so there's a lot to do over there. All right. Thank you so much for bearing with me and all the overtime and everything else. Lots of thoughts on all these cases, and I'm sure we'll talk about it. We've got, what do we got coming up? I think there's a couple of interesting things over the next couple of weeks that we'll have here while Dan is on vacation. So we're having lots of fun, and that's all that really matters. All right. Thanks again so much for joining me. It's been a great time, great fun. And we'll see you tomorrow morning. Have a great one. Be safe. And goodbye, everybody.